appeals are heard in the matter of Frangou and Frangos.
First of all, Mr. Fell, thank you for your email, which is about MEM and the judgment. We have that. And I see that we have some numbers.
Yes, maybe it's just in response to the idea of close of relationship yesterday, it just sets out where we say one finds the numbers in the accounts and how they add up.
I'm very grateful for you for that. Mr. Capt.
Good morning, my lady. Just to let you know about the direction of travel today, my intention is to finish all of my submissions on construction issues, including the quantum construction points by lunchtime, and then turn to implied rescission after lunch, handing back to Mr. Hill for his reply between 30 and 45 minutes before the end of the day.
Thank you very much.
So yesterday, when we broke off, I was beginning to address you on Clause 1 of the TTA behind Tab 8 of the core bundle. And I was explaining that Clause 1 of the TTA interrupts the status quo of the bailout and Ms. Frangou's otherwise complete control over the TT's fate. And it compels Ms. Frangou to ensure that Brandon remains the owner of the TT until the maturity of the 4 years tenor of the Brandon loan. You can get that from the words in parenthesis in the third line, which will remain the registered owner of the vessel until such time, and then until such time referring back up to upon maturity of the 4 years tenor. Said, absent this clause 1, Miss Frangou would have been free to procure that Brandon sell the TT at any time to anyone she chose for any reason. And this is therefore a heavy restraint on Miss Frangou. It completely curtails her commercial freedom to deal with the vessel as she sees fit in her best commercial interests. And it's quite possible that absent this clause 1, Miss Frangou may have acted, or wished to act, to cut Brandon's debt or trading losses with the TT and sell it sooner than at the expiry of the Brandon loan, either to restrict Brandon's losses or, if the market had unexpectedly bounced, to turn an opportunistic profit even. Now, it's right to acknowledge that Ms. Frangou's evidence was that nobody thought that an opportunistic bounce in the market would take place. But the judge decided, having heard all of the evidence, at paragraph 73 Roman 2 of the judgment, that both parties accepted prognostications about the market going forward were an uncertain or imperfect science. So it's by no means impossible that an opportunistic lift might have happened. One can take, for example, the COVID-19 pandemic, which came out of nowhere to instantly kill the shipping markets. But once the lockdowns were released, there was a dramatic rebound in the markets. And if that had all happened between 2011 and 2015, instead of between 2019 and 2022, it's possible that there might have been some sort of benefit to whoever owned the TT at that time. So with this dynamic in mind, I'd encourage you to view Miss Frangou's Clause 5 right to an indemnity as the price that Captain Frangos had to pay his sister for his right to buy back the TT, and the correlative restriction on Miss Frangou's ability to sell the TT caused by the need to keep the option open for 4 years. In rudimentary terms, Miss Frangou was saying to Captain Frangos, well, if you want to restrict me in using my commercial judgment in the next 4 years to best deal with the TT, I want the right to make you pay for that privilege if it's proven to be an economic disaster for Brandon, and therefore me. And after that point, when the option expires, it's up to Miss Frangou, as outright owner of the vessel, to speculate on and take on the risk of the TT's economic future, if she wants to. She can keep her indirect ownership of the TT and use it to her commercial advantage if she sees one, or Clause 5 allows her to immediately cash out as at 1 September 2015 and never think about the TT again if she chooses to sell it. And that's what the judge found was a commercial decision for Miss Frangou to take at the point she was required to make her election. My lords, this is all underscored by the thinking that Clause 5 was the quid pro quo for the TTA being concluded in the first place. And that's how the judge understood the dynamic. I'll just show you in the judgment the judge's findings about the genesis of the contract, because it seemed to be a point of interest yesterday. And it's paragraphs 17 to 20 of the judgment behind tab 7, page 119 to start with. Perhaps you might be able to read 17 to 20 to yourselves. My lords, you didn't have the benefit of hearing the evidence at trial, but it was a hotly disputed matter, the subject of oral evidence and examination, about whether the TT on Miss Frangou's case was a condition precedent to her agreeing to the bailout in the first case, or whether, as Captain Frangou's position, Captain Frangou said, Clause 5 was the quid pro quo for Clause 1. And read against that background of that evidential dispute at first instance, my submission...
Why is that an evidential dispute?
Well, because the background...
Why is that admissible evidence? Or why are the parties giving evidence in that respect at all? It's a question of interpretation of the contract.
Well, in my submission, the background context to why the agreement was concluded in the first place is relevant as an aid to construe.
Yeah, that wasn't what I was picking up, I thought. I thought your submission a moment ago was about the parties giving oral evidence about how they viewed the relationship between Clause 5 and Clause 1 or otherwise.
No, my lord, they gave evidence about why the TTA was concluded in the first place, why were they negotiating and trying to put together the TTA as an instrument off the back of the bailout. My lord, that question, at least yesterday, seemed to be playing on your lordship's minds, because if you start from the presumption that the TTA is a quid pro quo for the bailout would not have been concluded unless the TTA was going to be concluded. That can skew your interpretation of how long you might expect the indemnity to have been given for. So,
all that sounds like a dispute or other evidence going to the individual motivations of the parties, and that surely on first principles is inadmissible.
well, Lord, I would say
we're allowed
that...
to look at the objective background and the surrounding circumstances, but I mean, it's elementary. The particular subjective reasons why Party A or Party B enters into a contract is neither here nor there.
Well, Lord, if that's the position that you're willing to start from, complete neutrality as to the purpose of the agreement, and not starting looking at the TTA with the presumption that it was only going to be entered into, that the bailout was only going to happen if the TTA had been concluded, i.e. Captain Frangos had agreed to provide an indemnity to Miss Frangou that covered her entire exposure to the bailout, and I'm quite content to accept that position. What I'm addressing is, what I was concerned about yesterday is an impression that you might be inclined to start from a position that without the TTA, the bailout wouldn't have gone ahead, and that is not what the judge was thinking. Now, if that's completely neutral, and we're stripping that away, I'm content to move on, and I don't need to press this.
But, I mean, even in the paragraphs you referred us to, where the judge says, this is the entirety of the admissible matrix, I mean, the core of the admissible matrix is paragraph 18 of the judgment, isn't it? Which talks about the burdens taken on by Angeliki under the bailout.
Yes, in paragraph 17, but what it does is it draws a distinction. It shows that the judge was looking at the bailout as one concept, as part of the background to the TTA, not that the bailout and the TTA are entirely synonymous with each other, they're not one concept. He was splitting out that the bailout had happened and then looking to the TTA separately.
Don't we in any event have to construe the TTA itself, and it has some very comprehensive recitals which set out the background to it, and would that not be a better place for us to look?
Yes, my lady, thank you. So, my lords, returning to the TTA and back to clause 1. Still, I'm just going to go through the contract chronologically until we get to clause 5, building up as I go. So still on clause 1, but this is a point more relevant to the durability construction than the duration construction. In addition to the ownership restriction that clause 1 places on Ms Frangou, she's also compelled to agree that the TT may be sold to a company as determined by Captain Frangos if certain conditions precedent are met. But I'd ask you to note the final lines of the clause, which describe the company that will buy the TT is to be one of Captain Frangos's or his family control, or beneficially owned or controlled by a third party. And I suggest to you this is quite a strange phrase, because it seems to suggest the sale can be directed to happen in two discrete ways. First, to a company only controlled by Captain Frangos or his family, or second, to a company beneficially owned or controlled by a third party. We say it can't really have been intended that Captain Frangos was not entitled to have the vessel sold to a company beneficially owned by him or his family. But that's what the phrase might suggest, given only the word control is used in the first type of sale, and beneficial ownership is mentioned only for the second type of sale, giving rise perhaps to the inference that beneficial ownership is not an acceptable situation for a sale to a Captain Frangos or his family company. And we say that would be most unlikely to represent the party's intentions. And so, my lords, we say the only way to sensibly read this last line is that a sale can be made within or outside the family to a company beneficially owned, stop, or controlled, stop, by the family or a third party, as the case may be. Beneficially in this last line of the sentence does not condition control, it's attached to its usual partner, ownership. You don't need to say beneficial control to comport the idea of control, you just say control. You either control something or you don't. Other than the oddity in recital G, every time you see the word control in this document, it's on its own. And every time you see beneficial, it's talking about ownership. And we say, just as the judge found, in recital G, beneficial control, where the phrase is used there, is either an amalgam of both concepts of beneficial ownership and separately control, or it's just talking about beneficial ownership and the drafts people got muddled with their words in the course of putting it together.
In a sense, why does it?
Why do we care?
Yes. Why do we care? The operative words are to a company to be indicated to her by Mr. Frangos.
Yes, well, I'm just trying to use
Frangos.
it.
So, at the end of the day, in a sense, you could almost stop the clause there. The rest is just, in fact, expanding out.
Yes, I'm just using this to support my argument that in recital G, the meaning you get from the phrase beneficial control there is ownership by Miss Frangou, not control.
Okay.
Because otherwise, I'm just showing you the lax way in which the parties were using these concepts in the agreement, and the idea that just mentioning control cannot sensibly be meant to exclude ownership. Because if you go down that route, clause 1 doesn't make any sense.
Yeah.
My lords, on to clause 2. This clause has two important features. First, it concerns how monies obtained from trading the TT should be applied to Brandon's or the TT's Brandon's debts during the 4-year tenor of the Brandon loan, and what should happen to any residual money, i.e. profit, earned by the vessel at the end of the Brandon loan's 4-year tenor. So, my lords, here we see two things. First, strong focus on the Brandon loan's 4-year tenor, which I say is a theme of this contract, weaved into every clause. The second point here is that this clause is contemplating profits, because it's creating a priority order about how the funds coming in from trading should be apportioned. And the profits that do exist after all the debts, after all the loan repayments and expenses have been paid, are to be allocated to Captain Nicos's investment in the TT, the 7.8 million, which is cross-referenced to there by the reference to item I. That means recital I.
It's not really, although there's the reference to the balance, it's not really looking at profits, is it? It's just looking at monies coming in and how they're to be attributed. And a waterfall, and maybe you get as far as scraping away at the 7 million odd, which Captain Frangos provided. So it's not really profit necessarily. And it's a bit dangerous to call it profit, because what is profit when you've got large loans outstanding?
Yes, well, that's very fair, my lady. So what the clause is doing is it's contemplating that the vessel's trading income may exceed its expenditure and allow it to move on beyond simply repaying the debts to HSH.
But there may be some left to as I say,
Exactly.
scrape away at the 7 million.
But what's important about this is it contemplates that Miss Frangou may not be exposed, because her exposure to Brandon is only in relation to exposures to HSH if payments aren't being made during the 4-year tenor, or if there's a shortfall in the trading position. So if there is money left over after those two concepts to pay back Captain Nicos, Miss Frangou is at that point not suffering additional losses.
She's further up in the waterfall.
Exactly. So it conceives of a situation where the TT is doing rather better than Miss Frangou may have feared might be the case at the end of the 4 years. Because if there has been enough money to pay back Captain Nicos during the 4 years, she gets to the end of the 4-year tenor and she's not suffering a trading loss. And the only exposure she'd suffer at the end of the 4 years would be the difference between the balloon payment and the value of the vessel at that stage. Now this explains why being shut out of dealing with the TT during the currency of Captain Frangos' Clause 1 rights might be viewed as a source of serious curtailment of Miss Frangou's commercial freedom to take advantage of the market situation with respect to the TT in the way she might have wished to. Because if the TT was making a surplus beyond servicing its debts to HSH and paying its way through trading, she might have been of the view that was a good time to sell the vessel. So it shows that the parties contemplated a situation that might be something she might want to take advantage of, but Clause 1 means she can't do it. My lords, moving on to Clause 3A. This is the requirement that the TT's sale price from Brandon to the company that Captain Frangos directs it to be sold must equal or exceed the remaining debt of Brandon against HSH under the Brandon loan, or any shortfall in the operation and management of the vessel. So it approximates the breadth of the indemnity in Clause 5. It's trying to achieve the same thing to make sure Miss Frangou leaves the deal once the TT departs from Brandon's possession whole. But what I'd like you to note here is that just as we say is the case with Clause 5, her right to be made whole is triggered by reference to Captain Frangos' option being exercised. It cannot be divorced from it. So this is again Miss Frangou saying, if you want the TT back, you make me whole for any loss I've suffered in the period between the bailout being effected and the exercise of your option when I wasn't able to do anything with the vessel. And Clause 5 says the other side of this coin. If you don't buy the TT back at the end of your 4-year window, Miss Frangou also says, I want you to make me whole for any loss I've suffered when I was shut out from dealing with the vessel. So we say you just can't divorce, wherever you see it appear, Miss Frangou's entitlement to be made whole from the fate of Captain Frangos' option. Again, another point more in this sense towards the durability construction is the focus on Clause 3A, that any repayments of the trading losses are to be paid to Brandon or Miss Frangou directly. And I'll come on to this later, but this reflects the practical understanding and premise of this agreement, that Miss Frangou is essentially Brandon's alter ego, or that a trading loss suffered by Brandon is suffered identically and ultimately by Miss Frangou. And we say, my lord, that is because Miss Frangou was understood at all times to be the 100% beneficial owner of Brandon, and the person ultimately responsible for funding any losses, even if at first instance those losses were funded by men. And so what I want to leave you with before we go on to the durability construction later is the idea that what is of concern to these parties under this quite strange agreement, and what underpins the indemnity being payable to Miss Frangou, in both clauses 3 and 5, is who will ultimately fund Brandon's losses, not who will front them. Clause 3b requires HSH's consent to any sale under Clause 1 if the sale is to take place prior to the Brandon loan's maturity. And all I want to get from this clause, my lords, is that this envisages that Captain Frangos might exercise his option earlier than at the end of the 4-year tenor. And we say that when we come on to the election point and how the rights should be exercised, this agreement is sufficiently flexible to contemplate the idea that Captain Frangos might not be exercising his option right up to the deadline, and that it is possible to create space for both clauses 1 and clause 5 to coexist as successive obligations without the agreement falling apart. And I'll return to that later. Clause 3C, we see a similar concept to Clause 2, which envisages that the proceeds of a Clause 1 sale may exceed Brandon's exposure to HSH under the loan agreement and any management and operation losses. And if they do, they can be used towards paying down the Styliani loan, and that's the rump of debt that Captain Frangos' companies had to HSH under the old financing, which he agrees to bear. And he accepted a personal indebtedness for him. Once again, my lord, this shows the parties did envisage a possibility that the TT might turn a profit, or its value would rise such that a profit could be made upon its sale. They did turn their minds to that possibility. And this tends against Miss Frangou's worldview that on no possible outcome of this contract at the end of the 4 years could there be a surplus that might need to be distributed. And therefore, the idea that at 4 years it might not be attractive for her to keep hold of the vessel rather than sell it. Clause 3E returns to the sort of waterfall type concept, but it requires Captain Frangos to pay as much of Captain Nicos' initial investment back to him as is still outstanding, bearing in mind the Clause 2 requirement to pay some of that money back via vessel profits if there were any. So it's in order for Captain Frangos to get the TT back at the end of the 4 years, he needs to dip into his own pocket to repay his father, even if such funds are not generated by the TT. And the only point I make here is that Miss Frangou doesn't need to pay Captain Nicos back for that money if she is to sell or refinance the TT under hers Clause 5 rights. And that is the only reason why the judge referred to Captain Nicos' payment as a gift to Miss Frangou in the relative sense between siblings. To Captain Frangos, the money is a temporary loan if he wants the TT back. To Miss Frangou, she doesn't need in any eventuality to repay that money, even if the vessel is up at the end of the 4 years. I'd say no more than that. Clause 4 concerns what's to happen with an insurance indemnity if the vessel becomes a loss. And much as with Clause 2, the monies are payable in a waterfall fashion to pay off the Brandon loan, Miss Frangou, the Styliani loan, and then Captain Nicos, and then to Captain Frangos himself at the end of it. So again, we're anticipating that there might be a surplus here. And what I would say here, my lord, is that this clause only makes sense, my lords. It only makes sense if it's viewed as operating once again only during the pendency of the Brandon loan, the 4-year period. As my learned friend noted in his submissions, it starts off with "in the meantime." That phrase means in the meantime before it's decided whether the Clause 1 option is to be exercised or is exercised. And we say it can't be reconciled with applying to a position after the Brandon loan matures in any event, because on any of the exit strategies from the contract under Clause 5, it wouldn't have been intended that surplus monies would be used to pay down the Styliani loan or end up with Captain Frangos. Once you get to the Clause 5 situation, the parties have gone their separate ways. So this, again, is a clause that terminates on the 1st of September 2015. So, my lords, now we come to Clause 5. And in my submission, we arrive at it against the background that every clause up until we get here is concerned with the period within or at the conclusion of the 4-year tenor of the Brandon loan. And of course, my lords, we need to construe the TTA globally and not Clause 5 in a silo. So the question is, was Clause 5 alone intended to operate beyond the Brandon loan's tenor when every other clause in the TTA was restricted to operation in that 4-year period? And to answer that question, I would suggest one first has to look at the words of Clause 5, and then if that does not finally answer the question, look beyond to the wider terms of the TTA for help. And my lords, that is what I'm going to do. So, my lords, both parties and the judge break this clause down into 3 parts, and I will do the same. Part 1, I'm reading from the beginning of the clause down to the words in line 5, under the new loan, at the beginning of that line. This part 1 of the clause sets the parameters for the engagement of the indemnity that Captain Frangos gives in part 2 of the clause. And there are 2 joint initial hurdles that must be overcome before you get to part 2 of the clause. The conditions precedent to Captain Frangos' Clause 1 option must not have been met, and the TT must remain in the ownership of Brandon at the end of the 4-year tenor of the Brandon loan. And already, my lords, we see that Clause 5 is just as affected by and anchored in the 4-year tenor of the Brandon loan.
I mean, the second part of that is not really an additional condition. It's just a statement of what will be the case, isn't it? If the conditions under Clause 3 above have not been met, I mean, necessarily the vessel will remain in the ownership of Brandon Maritime at the end of the 4-year tenure, because you pointed out that it can't be sold because of the restriction in clause 1. I mean, it's not an additional condition, it's just a statement of what the position will be, isn't it?
As long as you assume that clause 1 has been complied with and Ms Frangou hasn't otherwise divested herself of an interest in it contrary to clause 1. So this may be.
I don't think most agreements don't, as it were, try and provide for what will happen in the event of a breach in that way. So, I mean, it's just saying, if there hasn't been an exercise of the option by John Frangos, brackets, in which case the vessel will be still in the ownership of Brandon at the end of the 4-year period, then, I mean, that's the way.
I can accept that, my lord.
Yeah.
But the more important point about that is after the comma, as you were discussing earlier, when the consequence of the vessel still being in the ownership of Brandon at the the end of the 4-year tenure, is that a right vests in Miss Frangou to sell the vessel. And the question is, why do those two go together? What's the sequitur linking those two concepts? And we say, we'll come back to in the durability construction, that the predicate of this part of the clause that engages the indemnity is that Miss Frangou, the vessel remains owned by Brandon, and Brandon remains owned by Miss Frangou. Otherwise, it's hard to see why the relevance that Brandon still owns the TT links to a right vesting in Miss Frangou to sell the vessel. She can't sell something that she doesn't own at the end of the day. Now, having looked at the hurdles to the engagement of the clause, one is then tasked with identifying when this putative right afforded to Miss Frangou arises and whether it is restricted in time. And, my lords, we say the natural wording of Part 1 only permits one answer, 1 September 2015. And there are two indicia in Part 1 of this clause that anchor the right of sale or refinance to no later than that date. The first are the words at the end of the 4-year tenure that we've been looking at. Now, the later words in the following lines, after the right to sale, at best possible available terms at the time, we say refer back to the period of the 4-year tenure on its natural reading. So this part of the clause is saying, when you get to the end of the 4-year tenure, defined precise date, if the introductory conditions are satisfied, Miss Frangou, you can sell or refinance the TT for the best possible price or best possible terms as are available at the end of the 4-year tenure. And if you do that, a right to an indemnity in Part 2 of Clause 5 opens up.
But how does it work? I mean, Angelica won't know whether John Frangos is going to exercise his Clause 1 right until the end of the 4-year period. You know, on the last stage, he could exercise at any point up till that date. He doesn't have to tell her.
Well, this is a function of the imperfect and brief nature of this agreement. If you look at this agreement, this has litigation written all over it because it is so short and so imprecise and so unclear as to the mechanics of how it would work that any number of disputes could have arisen about this contract. We just happen to be seized with one of them.
But why practical? I mean, isn't the practical reading of this that John Frangos has an option exercisable upon maturity of the 4-year tenure of the loan to acquire or to require the vessel to be sold back to him or to whoever he directs, subject to satisfaction of certain conditions. If he doesn't exercise it, then Angeliki has the right to sell the vessel or refinance on the best available terms that she can then get. I mean, it would take her time, or at least some time, to advertise the vessel for sale or to seek to refinance, which she can't do practically until she knows whether the option is going to be exercised by John.
In reality, in my submission, it would be quite clear, or either through a process of inquiry and exchanges, as parties would expect to be discussing with each other as you come up to a hard deadline, as we say exists in this contract, you would have a letter going out from Miss Frangou's team saying to Captain Frangos 6 months before the deadline, are you going to exercise your option? What's the position? Have you got?
He might just
say, none of your business.
He might do, and that might have led to a dispute, my lords. You see, so if there might be a dispute about whether, if Captain Frangos had kept
what's the basis for any suggestion that he has to tell her?
Well, I think, my lord, again, that dispute hasn't erupted, but there are, for example, implied terms of cooperation, Mackay and Dick.
Why? It's just an option.
Well, one has to, when the machinery in a contract doesn't explain in terms how two interacting rights are actually meant to interact in practice, one has to lean on the law, either through this interpretation.
Do you have any authority which, I mean, if you just have a simple option to acquire a piece of land or a piece of property, I mean, I don't see why you would imply a term dealing with the position before then. I mean, you might, but it's difficult to see this. I mean, there are just a series of conditions which you say you have to satisfy. But what's the basis of saying that there is some implied term that he would have to give her notice?
You have to start from the starting point that there is a fixed point at which Miss Frangou has to exercise her options by on 1 September 2015, not lead the question whether that is the right way to read the contract by how in practice the integration of the clause 1 option and the clause 5 option would work. Your starting point, which I have to persuade you of, is that there is a hard stop here. And then you have to work back from that question to see how the law will assist the parties in an imperfect short agreement to make that work.
I mean, doesn't that starting point elegantly beg the whole question?
Yes, so of course, but what
so,
I think...
frankly, how does it help us as an analytical tool?
Well, I think my Lord Justice Snowden is testing...
My inclination is to try and find a... Obviously, we all agree it's an imperfect agreement. We could all have drafted it better. But given we have what we have, we want to make it work as far as we can in a sensible manner. And on the face of it, nothing is less sensible than having an absolute potential collision right up to midnight on the 1st of September between exercise of the option by your client or exercise by Angeliki of her rights spelled out in Clause 5. I mean, on any sensible construction, they ought to be sequential, so that the question of exercise of the rights doesn't arise unless and until it is clear that the option has not been exercised. Only then does Angeliki have a free hand as to what to do with the vessel. And you can't, these things can't be done in a matter of seconds or minutes. Selling a vessel is I imagine, a pretty serious undertaking.
I agree, and you may well need to imply into this contract a requirement that Captain Frangos was to declare his option, his intention, elect between his option, to not, about maybe 6
we
3
don't
months.
have that. In the absence of that, he's entitled to exercise the option any time up to 11:59 and 59 seconds on the 1st of September.
And that would be an entirely unworkable situation that might have given rise to a major dispute between the parties.
So why is it unworkable? He knows the vessel. He's the one person who actually understands it. He doesn't need to do the sort of pre-purchase inquiries that a third party might need to do. I mean, so he can just all he needs to do is get his finance in order. There's a minimum price, which is specified at 3A. He needs to, and that minimum price will have certain consequences set out in the remainder of clause 3. But apart from that, that's all he needs to do. What Angeliki would need to do, if she was to want to sell or refinance, would be to have to advertise into the market that this vessel may be available for purchase. And the very first thing that any prospective purchaser would say is, what do you mean may? And she'd have to say, well, in fact, my brother's got an option over it. You, the purchaser, will have to take the risk that my brother will exercise his option and you won't be able to get it. Most purchasers in that sort of scenario will just say, well, I'm not interested.
Lord, I don't say that.
Come back to me as and when you can sell it, as opposed to telling me prospectively now I've got to sort of investigate the vessel, have it surveyed, arrange all my finance, on the footing that it could always be taken away if John Frangos decides to exercise his option, which has priority to mine.
I don't suggest at all that's how in practice the parties intended this contract to work. They would have intended, it might need some implication to get there, but they would have intended for an orderly exercise of the options in clause 1 and clause 5. Imagine a completely different contract where you do have a hard stop date and there are two successive rights, just a very simple contract, two successive rights like this. Is it really the case that it's beyond the wit of English law to imply into that contract a mechanism?
But you have the difficulty, and this may be a case in which the Marks and Spencer's view that interpretation and implication of terms are different. Don't you have the problem that you're trying to say, well, to make this work, you have to imply some terms into the exercise of the options in clause 1 and clause 5, whereas the alternative is you just read clause 5 and simply say that if those conditions are not met, then Angeliki has the right to sell or to refinance at the best possible available terms at the time, i.e. of sale, or refinancing. In other words, you don't need, all we need to do is interpret that first sentence of clause 5 in a way that simply allows a sequential
Perhaps
exercise.
I can answer that by coming on to my second indicium, which continues in the clause from where we were reading to, because the exercise of the sale or refinance option is then said to be in order to cover the then outstanding indebtedness to HSH under the new loan. That's the Brandon loan.
Yeah.
Everybody would have understood at the time this contract was concluded that the Brandon loan expired on the 1st of September 2015. That was the date by which it had to be fully paid off or it went into default.
Yeah, but it could go into default and it would increase.
My lord, this goes into the comment you made earlier about not assuming a breach in a contract. Nobody is going to be sitting on the 1st of September 2011 when this contract's concluded expecting a breach of the Brandon loan to occur 4 years later, because that puts you right back in the situation you were in when the bailout took place, with HSH arresting the vessel and the entire turmoil that this very contract was intended to avoid. So I say the only rational expectation that the parties could have had at the time this contract was concluded is that the balloon payment is paid on the 1st of September 2015, one way or another, whether that's via a sale, a refinance, someone paying the balloon payment in this very wealthy family as we'll look at. But when you look at the qualifying words of the first part of this clause, there is no way that a sale or refinancing to deal with the outstanding indebtedness to HSH under the new loan, the Brandon loan, can contain within it any notion of a date after the 1st of September 2015. And perhaps I can show you the Brandon loan itself to show you how clearly it was intended and understood that loan comes to an end on the 1st of September 2015.
I think you can accept that without your taking
You can accept that
to it.
If you'd like me to just give you the reference, I can, but it's clauses 8.1 and 8.2 of the Brandon loan, which is in the supplementary bundle behind tab 17 at page 261. And that makes clear that on the 1st of September 2015, the Brandon loan was no more. And that's entirely consistent with the rest of the TTA.
Well, sorry, you say the Brandon loan is no more. I mean, the Brandon loan is due to be repaid, but there are provisions in the Brandon loan agreement, doubtless, that if it's not repaid, there will be default interest, etc., etc. It doesn't just suddenly stop and disappear in a puff of smoke.
But the expectation in this contract baked into it is not of default, my lord. So when you're standing in the party's shoes at the time the contract's concluded, would they really be thinking, when you see a reference to indebtedness under the Brandon loan, that's by reference to a period years after the Brandon loan was meant to finish, and you're in a default position where interest has been racking up, and you're in a completely different world where the vessel may have been rearrested, and exactly the position that the whole TTA was designed to avoid?
Well, I would have thought that what they might, if we're talking about practicality, I mean, what's clear for the protection of your client is that to minimise his exposure under the indemnity in clause 5, under clause 5, the terms of sale have to be at the best possible price from his perspective. And it seems counterintuitive to me that would be the case if you forced a sale on the nose on the 1st of September 2015 at a time when you would only ever have been able to go into market and advertise it for sale subject to a prior right for exercise of the option. You couldn't offer it for sale unconditionally, nor could you in fact go to somebody to refinance it unconditionally, because the very first thing you'd have to say to a prospective purchaser or new financier is, actually, I may not be in a position to sell it because I may have had to sell it to John, who's got the right to elect to buy it all the way up to the 1st of September, so that the price, irrespective of the market conditions on that date, as to whether that was a particularly opportune time to sell, just the very circumstances into which you would be going, well, I think would suggest that you're not going to get the best price.
Well, it's not the best price for John, it's the best available terms at the time. That means if you're forced to sell at the time, you do the best you can.
The whole point of that term, it's classic, the whole point of that term is to protect your client. In other words, it's to stop Angeliki saying, look, I don't really care what I'll sell it for because I can always claim the balance against John. It is for his protection.
Yes.
So you have to approach that clause on the basis that the parties would have expected.
It's for his protection on the day, but it doesn't stop her triggering the indemnity at any time she wants. So on the day that if I'm right that the clause requires her to sell on the 1st of September 2015, you're right, my lord. This stops her from getting a bad deal. She has to get the best deal that she can. She can't just not turn her mind to it. But that doesn't stop her from, even on my learned friend's case, from triggering the indemnity at any point, actually in 19 years.
No, but when she wants to. But your point is she has to sell.
Yes.
On the 1st of September 2015, yes. The moment after John's ability to exercise the option expires, yes. Whether it's a good or bad time, however she's been able to market it previously.
If she wants the benefit of the indemnity, she's not required to sell by this clause. She has a right to, an option to sell. She doesn't have to do it. But you're right, but this is all bad for Captain Frangos, my lord. It's not bad for Miss Frangou. This clause allows her to wash her hands of the TT after 4 years. And she can say, look, I've had enough of it. I want to wash my hands of the bailout. Yeah. It's all back on you, Captain Frangos. Yeah. I'm triggering the indemnity. I've been put out of the vessel for 4 years. You've stopped me from doing what I want with it. I don't want this vessel. I never wanted it. Time's up. Yep. I'm going to do the best I can for you on this day, but that's it. That's all I owe you.
Why does she have to do that? I was with you all the way up to the last bit. Why does she have to do the best for him on that day if by conducting the sale thereafter she can get a better price? It may take her a month or two to sell thereafter, because she can then go into the market and say, I now can sell, Brandon, I can procure Brandon to sell. Anybody who is interested in buying it, there's no other rights over the vessel. Give me your best price. And that may be a better thing for John.
It may be, but it may be not. And the point is, Captain Frangos isn't underwriting the economic fortunes of the vessel beyond the 4-year period of the Brandon loan. After that period, Miss Frangou is speculating. She may be doing it for Captain Frangos' benefit, but she may get it wrong, and he's not taking the risk of her getting it wrong. So he doesn't get the benefit of her getting it right, but he's not. The risk passes back to Miss Frangou at that stage. If she chooses not to exercise the option, she's got a right to say, that's it, I'm out. 1st of September 2015, I never want to see or hear from you again. I don't want to hear about this vessel ever again.
But only on your argument, if she's managed to pre-organise a sale for that very moment.
Well, on the judge's analysis of election, all she has to do is declare which of the two options that she wants to go for.
But that's not your position.
That wasn't my primary position at trial. I support the judge's decision on it in this court, and as an alternative, say she had to complete. And then we get back in, but this is why,
It's not normally a sort of very solid foundation for an implied term, which I think is what the judge has ended up with, because I don't really understand how he's constructed the concept of an election other than by implication. Perhaps you can help me on that. But it's not normally the best starting point for an implied term that it didn't occur to anybody prior to the judge raising the point at the hearing.
The judge finessed in my submission about it. We'll come on to the election later, but effectively what he's saying is that you can exercise your right of sale by simply indicating which of those rights you are exercising without actually completing.
What was he doing? Was he implying a term, or was he interpreting the agreement? And if so, which words was he interpreting to arrive at the concept of an election?
Well, in my submission, he was interpreting, not going down the road of implication.
So how do you interpret any of these words to arrive at the idea that what's involved is actually not a sale or refinancing, but an election?
Well, I think the way you get there, my lord, is start from my proposition at trial, which was that you had to complete everything by the 1st of September 2015. And the judge clearly wasn't attracted to that. Perhaps he felt it was too draconian. So he tries to help, in a sense, relax the requirements on Miss Frangou as a softening of the strictures she would have been under, to say, well, no, I don't agree with Mr. Capt. You don't have to go through the whole process of selling it, such that you'd have to start 3 to 6 months before your option was meant to come up. All you had to do was decide which of the two routes you wanted to go. The exercise of the option, the election, as he termed it, was effectively her exercising her rights, but just not completing the process that the exercise of those rights ultimately leads to. So it was a mitigation of the harshness that he must have perceived in the way I was running the case.
I'm not really sure that's an answer to the question of what was the judge actually doing. Was he interpreting or was he implying? I mean, you sort of explained his motivation, which sounds remarkably like the court refashioning an agreement to make it reasonable. But putting that aside, what was he actually doing, do you say? Was he actually interpreting, or was he...
Yes, he was saying he was interpreting.
So which words?
The words, Angeliki Frangou has the right to sell a vessel at fair market value or to refinance.
So how do you interpret the words has the right to sell as meaning has to make an election?
Which has
I'm just struggling with the concept of interpreting those words.
I appreciate that one. The right is to sell or refinance, and the judge's interpretation of that right was that in order to exercise it, all you needed to do was communicate your intention to exercise that right, which one of the two you were going to do, sale or refinance. And that was sufficient to stop time for you to have exercised your rights before the deadline day that we said and he agreed was imposed by this clause. And you didn't need to go beyond that, whereas my submission had been you not only need to decide whether you're going to sell or refinance, but you also need to have actually completed that process. Otherwise, you haven't got far enough along in your rights to satisfy the deadline. But of course, in a sense, this is a bit of a side issue. I say that because Miss Frangou's case is that she exercised her rights in 2020. There's no dispute in this case about whether and how she exercised her rights on the cusp of the deadline has been done in accordance with what the parties intended. So we're using this to test the constructions, but it's not actually the focal interpretative challenge.
It is absolutely critical, because unless you can get your interpretation off the ground on the face of it, she has an unlimited time throughout the remainder of the life of the vessel. In order to cut down that, it's absolutely essential to work out what was intended to happen on the expiry of the 4 years. And on your interpretation, even if at 1 minute past midnight she'd made her election in terms posited by the judge, that would not have worked. She'd have left it too late.
Well, I think the judge was willing to introduce a de minimis.
Well, why? Where do you get that from?
Well, in his judgment.
The normal rule with options is, the time for exercise is specified. You don't have a kind of time is not of the essence or anything like that. An option means what it says. If you have to exercise it by Monday the 15th of December, you have to exercise it before midnight on that day, and there's no room for any latitude.
Well, Lord, I agree with that. And my proposition is that this contract does have a very hard deadline.
But it just doesn't say it. That's the problem. It does say it in relation to your client's exercise of his option, but it conspicuously doesn't say it in Clause 5. All it says is you have a starting position that the conditions under Clause 3 have not been met and the vessel remains in the ownership of Brandon. So far, that all looks open-ended. And then we're told Angeliki has two rights, either to sell or to refinance. And then the words, at best possible available terms at the time. And on a natural reading, that seems to me to refer to the time of sale. And your construction would be much stronger if the words had been at that time, which is the point I was putting to Mr. Hill yesterday.
Possibly. Possibly that's right, my lord, but I still say the words at the time refers back to the end of the 4-year tenure, which conspicuously...
I know you do, but it's not self-evident that it must refer to that rather than to... at that time, it would make it unambiguous. And if there is any ambiguity there, it seems to me the more natural reading is to take the words as referring to the date of sale or refinancing.
My lord, what the clause doesn't say is at the end of the 4-year tenure or thereafter. So if you just read at the 4-year tenure as indicating a forward as stopping at that time, the condition of the ownership of Brandon Maritime seems to only stop at that point anyway. But clearly a condition...
Yeah, on the face of it, it seems to, if anything is implicit, it seems to me that Angelique's right only arises at the end of the 4-year period. In other words, at midnight on the 1st of September. In which case, it only arises at a certain time when it's, on your view, it's already too late to exercise it.
Well, my lord, in my submission, if this clause, if the first part of clause 5 was intended to look beyond a snap point at the end of the 4-year tenure, midnight on the midnight, you'd see you might see something such as at the end of the 4-year tenure or thereafter, indicating that the requirement for the ownership of Brandon, that the vessel to remain in the ownership of Brandon persisted, because that's a predicate to having an option to sell, and you don't see that there. But what you do have is at the end of the clause, a reference to the indebtedness of HSH under the new loan, which I say reframes everything back into the period of the 4-year tenure of the loan. When you read this clause, in situ in an agreement that has as its only purpose, otherwise, regulating rights and liabilities within a 4-year period.
Just picking up my lord's point about the sequential timing of this, as I understand it, you read the words at the time to mean at the end of the 4-year period, is that right?
Yes.
So on the judge's interpretation, Angeliki has to elect at the end of the 4-year period. But she doesn't, according to the judge, have to have concluded a sale contract as at that date. So how long does she have to conclude the sale contract?
Well, again, my lord, that is an issue that didn't arise in this case because
we're interpreting the contract, which is we're supposed to be looking at what the parties would at the time they made it have understood it to mean.
Agreed.
So let's assume that they would have understood that to require an election by Angeliki immediately upon the same point in time that John doesn't exercise the option. And the judge's interpretation is it's just an election. She doesn't have to have actually concluded the sale at that time. So how long would the parties have understood on this view of the meaning of this contract that she would have to conclude the sale?
Well, the parties don't specify, and in circumstances such as that, you'd probably imply a reasonable time.
Right.
So
how does she exercise, if a reasonable time elapses and she then arranges the sale, how can that be on the best available terms at the time, if your meaning of at the time was at the end of the 4-year period? I mean, it would surely mean at the best available terms at the time of the subsequent sale, not, I mean, how can you sell later but at the best terms which were available at the end of the 4-year period? It doesn't make any sense.
I accept that. So perhaps on that way of looking at it, at the time would refer to the time of sale.
Right.
So that would undercut the first facet I was talking about, but it doesn't touch the reference to the new loan, which otherwise anchors things within the 4 years.
Well, but it's just saying. But if it's if you accept that the words at the time do mean at the time of the sale, then it definitely does mean that it's the indebtedness to the bank at the time of the sale, because it says best available terms at the time. In order to cover the then outstanding indebtedness, the then must refer back to at the time.
Well, I would say the then refers back to the 4-year tenor, my lord, which is the opening.
So wait a minute. So in the same sentence, you've got the words "at the time" referring to the time of sale, and in the same line where it says the then outstanding indebtedness, that doesn't refer back to the immediately preceding mentioning of time, but goes back to the end of the 4-year period.
On the judge's election
That makes no
analysis.
sense.
Yes, on the judge's... my lord, I wouldn't suggest it doesn't make sense. You have a concept that frames this clause of a time period at the end of the 4-year tenor. On the judge's election analysis, the sale doesn't need to be completed until after the deadline, and at the time, if at the time refers to the time of the sale, and I accept your point about that. But then, in order to cover the then outstanding indebtedness to HSH under the new loan, refers back quite naturally, I would say, to the point at the end of the 4-year tenor, which is talking about the new loan. The then outstanding indebtedness to HSH under the new loan, the only reference you've got to reference point to what time period you're talking about in this contract is at the end of the 4-year tenor, at the end of the loan's lifetime. I've made my point about it. I don't want to...
I think we've got those points, Mr. Captain. I'm very grateful. And basically, you've given us the pointers of the parameters of the 4-year tenor and the loan, etc., and the way that you interpret it, and you've attempted also to support the way in which the judge interpreted it. But we haven't got beyond the first sentence, so I think we need to go.
Yes. Well, they're done great. Well, I hope it was of use, even if it did take time. But of course, my lord, the problems you're identifying with the election analysis don't arise on my alternative hypothesis that everything had to be completed, the sale out or refinancing had to be completed by the 1st of September 2015, which I obviously rely on contingently as an alternative to the judge's formulation. But I accept that brings into play your concerns about how the options would be successfully exercised when they appear to both coalesce around the same date. And you have my point on that, which is that the law is well able to deal with that sort of problem when the parties haven't turned their minds to the mechanics in the contract. Part 2 of the clause, my lords, is the indemnity and frames the indemnity. Again, I've got the same point, which I won't labour, but it's talking about the indebtedness under the new loan. And I say that can only be a reference to something that expired on the 1st of September 2015, and the parties wouldn't have intended, when this contract was written, to expect the indebtedness under a loan that had already been intended to have matured to be governing the extent of an indemnity here. So, but I won't labour that point beyond what I've just said. The second point to note about this is the indemnity is owed to Ms Frangou directly. You discussed this yesterday in connection with the durability assessment, and we'll come back to that when I deal with that point in more detail. Further, I don't think this is in dispute, as the judge found this part of the clause necessarily requires that proceeds from a compliant sale or refinancing have crystallised in order to engage the indemnity in this part of the clause. So if there is no compliant Part 1 sale, then you don't get to Part 2. You have to go through that in order to qualify for the indemnity. The other point I want to make about the indemnity here is that the indemnity crystallises only once. So if Ms Frangou refinances in accordance with this clause, she gets her compliantly, she gets her indemnity in Part 2. But if the TT after that point, under its new financing, assuming she refinances, continues to make a loss, either trading or capital under its new financing, she has no continued right of recourse against Captain Frangos. There's no second indemnity. So the purpose of this indemnity is not, and never was, to hold Ms Frangou entirely harmless from the full effects of the bailout. At some point it envisages necessarily, as is the case entirely without the TTA and just the bailout, that she is at sole risk for the vessel's economic fortunes. And my lord, this underscores how, even just looking internally at the contract, to take the starting point of the TTA as
Sorry, I'm not sure I followed that submission. I thought you just submitted that in order to get to the indemnity in the second sentence, there has to be a compliant sale or refinancing.
Yes.
if there's a sale,
Got it.
that in a sense it all stops.
Yes, agreed.
It's crystallised. Is your point what, that if there's a refinancing?
She stays the owner of the vessel.
Correct.
The indemnity is crystallised.
Yes.
And from that point onwards, she takes the economic risk in the vessel making a loss during the course of that refinancing.
Yes. So, but the crystallisation of the indemnity will require John Frangos to pay the shortfall and any accumulated losses to that point.
Exactly.
Whatever that means. And the refinance in its refinance state, it's then, you say, at risk so far as Angelique is concerned. It's down to her thereafter.
Yes.
Subject to the clawback in the last sentence.
Which benefits only Captain Frangos.
Right.
So she bears the loss.
Sorry, we are. Sorry, I just thought I misunderstood what you were saying.
So my point is that this contract envisages that at some point, Ms. Frangou may be solely responsible for the effects of the bailout, and so therefore that tends against the idea that this contract was meant to be a panacea for her.
Sorry.
Against
But the point is, if the shortfall and the accumulated losses, why wouldn't she be made whole by that?
Well, that only because the shortfall and accumulated losses are fixed in time once she engages the indemnity by the refinancing. But the vessel continues to trade during the future refinancing.
True,
period.
but she'll be made whole as at that point by the indemnity.
But if the vessel continues to lose money after the point the indemnity is crystallised, she has no right to go back to Captain Frangos 4 years later in the second period of the refinancing and to once again say, I'm refinancing again, I'll have a second indemnity.
Right.
So this contract envisages that she will at some point, if she chooses to refinance and not sell, become solely responsible for the economic fortunes of the vessel, solely lumbered with the consequences of the bailout.
Well, it's that.
After a certain...
That's the last point.
It's the last. The first point, my ladies. There.
No, I understand entirely what you're saying in the sense that once a sale or a refinancing has occurred, the guillotine comes down, and thereafter it's either it's been sold or it's Angelique's problem.
Yes.
Put it that way.
Yes.
And that is how I understand the words of Clause 5. But I don't understand that your last tag, which is, and thereafter, Angelique becomes responsible for the consequences of the bailout. Because this is all being a situation which has arisen, which the family have dealt with in this way. Clause 5 creates an end date, query when that is, and that end date is a sale of the vessel or a refinancing, in the sense that new terms, whether with the same or a different provider of finance, kick in. That doesn't mean that from that moment, or I don't understand it to mean, and that's why I would like to understand why you say it means, that from that date, Angelique has taken on the consequences of the bailout. She has just decided that, all things being equal, she'd like to keep the Brandon, and to keep the Brandon and to get the indemnity, she will enter into new loans.
And so if that's right, if that's baked into the contract at some point, there's nothing inherently illogical or uncommercial about that point being the 1st of September 2015, where she has the same choice to sell or refinance. And at that point, the exposure from the bailout, as it continues prospectively from the moment of the crystallization of the indemnity, rests on her. This agreement contemplates that liability at some point prospectively.
It's just that use of the word consequences of the bailout. It just seems to me that she chooses to keep the vessel. That's all. And I don't understand that she's taking on any consequences of anything. She's just at that date deciding, I'm not going to sell the Brandon, I'm going to carry on. And the way that one carries on with ships is to finance them. Hey presto, that's it. But So I just don't get that last
The
little.
point is that this underscores that the TTA has baked into it the idea that Ms. Frangou's protections from Captain Frangos may be limited in time, and at some point
Yeah,
she will take economic responsibility for the fate of
Fine.
the TT.
fine. I think we
And if
understand
that's
that.
part of the contract inherently, there's nothing inherently unusual or wrong with that point in time being fixed at the 1st of September 2015.
Well, there is if
As
it's
we
not practical.
Well,
And you would say, in your client's favour also, that it can't be expected that this drifts on forever, as you are saying, partly because it's tied to what's outstanding in the indebtedness to HSH under the new loan, and one could just let it drift and let the interest rack up, and it will be on the head of your client.
yes, and we say that's one of the reasons why you shouldn't read the indemnity as being as wide as my learned friends would say.
Yes. Anyhow, I'm sorry, I took you off your
Not at all, no,
course.
that was very helpful. So just tying together the way I say you should read this contract. In my submission, this is building on submissions I put in writing at paragraphs 41 to 46 of my skeleton, developing first my submission that the 4-year tenor of the Brandon loan is weaved into the contract such that you can't read clause 5 independent of that integral feature that regulates all of the rights and liabilities that are being governed by the contract. And in my submission, you should read the contract, the TTA, as being an interim agreement holding the ring in respect of the TT during the 4-year tenor of the Brandon loan and the currency of Captain Frangos' buyback option. And that is what the judge found as his interpretation of the agreement at paragraph 41 of the judgment. You were taken yesterday, I think, to a different part of the judgment where he was reciting submissions about this, but he actually, in terms, concludes, as a matter of his judgment, this was the raison d'etre of the TTA at paragraph 41. And you would need to overturn his decision about that, his impression about that, in order to find in my learned friend's favour. In my submission, the TTA is best viewed as an emergency agreement designed to handle the immediate aftermath of the bailout. And we know that Captain Frangos felt aggrieved and wanted the TT back, and Miss Frangou had entered into a commercially dubious bailout at the forceful behest of her father. The way I would encourage you to read clauses 1 and 5 are as mutually exclusive exit strategies for Captain Frangos and Miss Frangou from their short-term and reluctant entanglement with each other and the TT. They are opposite ways, after the Brandon loan matures, at the 4-year point, for each of the siblings to thereafter be able to deal with the TT to the effective practical exclusion of the other, save for the narrow circumstances in which the clawback operates.
What do you say about the last sentence of clause 5? Because that is seems to be open-ended. It gives John the opportunity to take the benefit of profits going forwards, and therefore to have Angeliki pay back monies that he has paid to her. But it appears to be open-ended.
In my submission, it only applies up until the end of the refinancing that Miss Frangou has taken out, so it wouldn't be a right in perpetuity if she were to refinance again. His entitlement under Part 3 ceases. The way I would suggest you read Part 3 of that clause is as an immediately successive period to the refinancing. He has the entitlement to this limited clawback. It peeps over the 4-year period, but doesn't extend into a permanent right to him, no matter what she does with the TT thereafter, it doesn't always have to account to him beyond that initial refinancing.
Okay, so but she can choose as much as any borrower can choose the length of that new loan.
Yes, if she were so minded, she could refinance 1 month later and That's the end of his right to have his whatever he's paid to her reimbursed. Would be maybe if that had been a dispute that erupted under the contract, maybe there'd be an argument about whether that was what would be intended. Maybe there'd be some sort of implied obligation of good faith or something of that nature, the post office case type obligation.
Sorry, I think I might have just misunderstood you. So she decides to refinance instead of sell. She refinances on the basis of a 10-year loan. This may be completely nonsense in the shipping world, but for example, for 10 years. But does the last sentence not mean that if there are profits within that 10 years, they go to reduce? It could be 10 years, 2 years, 4 years, 7 years, anything, 1 year.
But there's nothing to stop her doing one refinancing that lasts for 10 years, but after only 6 months of that, refinancing again voluntarily.
Yeah, and then you say that would be the cut-off.
Exactly.
I understand. I'm sorry, I misunderstood that last
sure.
part. Thank you.
But there is still the point, isn't there? At least it seems to me there is the point that on any view, the third sentence, third limb, whatever you call it, of clause 5, does have a potentially operate for an uncertain future period, coextensive with the date with the length of the refinancing. And to that extent, it does show, looking at the agreement as a whole, as we have to, the parties obviously contemplated it, at least in this respect. It was not going to all have to be it's not just a purely interim measure which only operates for the 4-year term or tenor of the new loan.
It does peep over the 4-year horizon, but what's significant about that period is that Ms. Frangou has no further right to an indemnity in that period, because she's already refinanced and crystallised the indemnity.
I understand that, but however, the fact that potentially relevant events were contemplated by the parties as taking place during that longer time frame may possibly encourage one to a construction of the first part of clause 5, which is not to tie it as stringently as you would have us to the date of expiry of the 4-year term. It's only an indicator.
My submission is just it's one slither of the entire contract, which is otherwise all directed the other way, convincingly so. And it's not enough on its own to undermine what I would describe as the force of my submission.
I certainly don't suggest it's more than a factor. It is something we have to put into the mix.
I agree with that.
But just so I understand how refinancing would work, whenever the date is, let's not get hung up on the date for a second. When there is a refinancing, a new lender comes in and says, well, I will lend you, Brandon, X to finance your operations of this vessel. You know, whether it's charter security or not, who knows. But X may be less than the amount outstanding to HSH at the time, but quite likely to be. But it's the best offer that Angeliki can get from another institution. Now, at that stage, there's an identifiable shortfall, i.e. the difference between the amount outstanding to HSH and the amount of the new loan. And that's prima facie the amount for which Angeliki would be called on her guarantee by HSH. So she gets an indemnity from John in that respect for that shortfall. So in capital terms, as it were, her taking on the bailout, the consequences of the bailout are neutralised. In other words, if she takes on a refinancing and gives a guarantee to the new lender, well, that's her. That's her choice.
Yes.
In between times, Brandon may have incurred losses, and it was explained to us yesterday that they are almost invariably likely to be shown as a debt owed to the management company, which is Angeliki's company, because that's the way it was designed to operate. So that at that stage, the indemnity also picks up the accumulated operating losses, which is synonymous, it is said, with the debt owed to the management company. So again, at that point, all the consequences of the bailout, as far as Angeliki are concerned, are addressed and neutralised. It's then for her to take a risk for the future with the trading of or the operations of this vessel, which she has decided not to sell but to refinance. And the clawback provision operates such that if in fact it turns out that it's a profitable vessel to operate because of the circumstances that prevail thereafter, that there's a clawback in favour of John.
Agreed.
Now that's the mechanism that I understand you're submitting, and I understand, but why does that have any, I mean, that seems a perfectly workable solution. I don't understand why it necessitates tying everything to the 4-year period, for example.
Because we say after that 4-year period, Captain Frangos didn't agree to underwrite the economic fortunes of the vessel. He only looked 4 years into the future and said, if things go badly during this period, I'm willing to write you a check.
He agreed to underwrite the economic fortunes of the vehicle until it could either be sold or refinanced.
We say there's a finite period at which, if he was going to underwrite the economic fortunes of the vessel, everything had to be crystallised by. Because if Miss Frangou, I mean, you can just look at this case as an example. The trading debts of the TT in 2015 were 4 to 5 million. By the time we get to 2020, when the vessel's sold, they're 9 million. They've doubled. So that's not great for Captain Frangos. So what he wasn't doing, we say, when he agreed to this indemnity, is saying, I'm going to look into the future 9 years into the shipping markets and say that whatever happens to the vessel, I'll make you whole for Brandon's losses over that 9 year period.
The difference between the parties, as I see it, is really that your contention is that the indemnity doesn't go beyond the end of the 4-year tenor at all by a minute. The judge says actually it does. It goes for an indeterminate period beyond the end of the 4-year period, but subject to an election. And the other side say it goes until the vessel is either sold or refinanced.
I think the middle stage of that may be a misconception of the judge's approach, because in my submission, the judge crystallises the loss, the exposure under the indemnity at the point of the election. It's just the practical manifestation of that sale or refinance can take place after, but the time stops for the quantum of the indemnity at the time the election is made. Now that can work in both ways for the litigants. For Captain Frangos, it may not work out very well if more repayments have been made under the loan.
Well, we've had the debate about,
Yes.
Well, we've also had the debate about the difficulty of the timing, the phases of timing of
Yes.
crystallising the loss at the end of the 4-year period, but talking about the outstanding indebtedness. Anyway, okay, we've been over that circuit. Right, okay, got you. Yeah, I understand.
So is there anything more that you'd like to say about Clause 5?
Not specifically about Clause 5. I was going to take you to the parts of the judge's judgment of what he decides about how the TTA works and about Clause 5, just to tie together after what I've said about it. You can see, and this is building on submissions made at paragraph 50 of my skeleton. But I think we can take it more easily by having a look in the judgment, and you'll be able to see what I've written at paragraph 50, which represents what I'm saying now. So starting in paragraph 64 of the judgment, this is what I'm discussing at paragraph 50A of my skeleton. This is the reference to the sustained 4-year tenor of the Brandon loan, and the judge's view that there were no other temporal markers in the document of the TTA's intended longevity or scope. Then at paragraph 68 of the judgment, we have his decision about the election, which we've discussed already, and I may not need to come back to, but I'll just consider that in a moment. Then at paragraph 70 to 71 of the judgment, the judge was struck by the position that Miss Frangou had a right, but not an obligation to sell and refinance the TT under Clause 5 so as to engage the indemnity. And so, because she had a right, she also had a sort of negative right, if you will, to take a different course, not to exercise her option. She might wish to privately with HSH extend the Brandon loan, or she might wish to pay the balloon payment in cash, or someone else might pay the balloon payment in cash, perhaps the father. And then she was left at that point to trade through to profitability at her commercial risk, which is what the judge decides was a reasonable inference to draw about how she may have been thinking, or how she might have thought, at paragraph 71 of the judgment. And you see, and I showed you earlier, paragraph 73(2) of the judgment, where the judge dismisses the idea that one couldn't have expected by looking to the future markets that with certainty the vessel wouldn't be profitable, such that you might just want to own us outright after 4 years or something like that. And then at paragraph 72 and 73(6), the judge was struck by the idea that Miss Frangou's construction has the unlikely to have been intended corollary, that Captain Frangos' indemnity was open-ended during a 19-year lifespan of the TT, even though he'd given up all control over the TT, which was instantly vested in Miss Frangou when the TT was concluded, and his buyback right only lasted 4 years, the duration of the Brandon loan. And the judge reasoned that that sort of temporal disparity between the extent of the Clause 1 right and the Clause 5 right inverted the genesis of the TTA as he saw it, or even looking within the contract, the primacy of the Clause 1 right over the Clause 5 right. It was to effectively allow the cart to lead the horse. And then the judge continued at paragraph 73 in quite a lot of detail to cross-check his preferred construction against the family and other contextual background to the TTA. His points there included, over the page at 73.3, that the whole deal, the whole bailout was family-led and father-inspired, involving mutual compromise and sacrifice. It was not a perfect, watertight deal between rational commercial actors at arm's length. And that influences the logicality of some of the consequences we've been discussing this morning, and the likelihood that they may just have been features of this agreement that the parties acting quickly to get something like the TTA together may not have turned their minds to, and may have led to a whole host of problems had different issues cropped up in this case. But that's not a reason to depart from what the parties actually agreed. At 73.4, Roman 4, the judge noted that the fact that TTA did not cater for every eventuality in which Miss Frangou might suffer an exposure as the result of the bailout was not determinative. He surmised, having heard evidence, that it was quite possible Captain Nicos, the father, might have stepped in to make Miss Frangou whole if there was a gap in the TTA. And he'd already supplied $8 million to help with the plan. And so tying in with the idea that the TTA is a short, imperfect, and father-backed emergency bailout for the family name, we say that it may well be a document that contains lacunae that everyone would have expected to have been filled by further agreement, or if not possible, further paternal imposition or paternal contribution. And at paragraph 39D of my learned friend's skeleton, he says the judge's inference here that Captain Nicos may have stepped in to fill the void is speculation, but I would disagree with that. And I'll just show you that by reference to one part of Miss Frangou's evidence from trial, which is in the supplementary bundle in her second statement, tab 12, on page 162. This is just to show you something that the judge was aware of that you might not otherwise be aware of, and which doesn't appear in his judgment. But this, of course, just segueing for a moment, as you'll appreciate, as the trial judge, he was exposed to a whole variety of evidence that isn't in the judgment that may have impacted his decisions.
Sorry,
you're going
to have to give me the reference again.
Sorry, it's the supplementary bundle, tab 12. This is Miss Frangou's second statement from trial. I was just making the point, my lord, that the judge was exposed to a lot of evidence that he heard and absorbed, which not all of it made its way into the judgment, but may still have influenced his impressions and the inferences he's drawn from primary facts, which is why I say you should afford him. Now, I just want to show you paragraph 24 in particular, and this records in the third to sixth lines, that you may not appreciate that in 2011, earlier in the year, the father had given Captain Frangos 30 million euros to part pay a debt that Captain Frangos had, a 60 million euro debt that Captain Frangos had sustained to his ex-father-in-law. And then in paragraph 25, we see reference to the 7.8 million that the father provided in relation to this situation. And then it's recorded in paragraph 26, the father gave Captain Frangos another 10 million euros, also relating to the debt he owed to his father-in-law. So what I want to just show you, that the judge will have, of course, been aware of that this is an incredibly wealthy family with incredibly large sums of money floating around between the participants to the family, that, you know, tens of millions of dollars floating around in the way that we in this room might do with hundreds of pounds. And it is no way speculative to presume that with this sort of wealth, that somebody might have been able to find $20 million if it had been required to pay the balloon payment at the end of the TTA, if some sort of situation had eventuated where otherwise Miss Frangou was going to end up footing the bill.
So you're telling us this because it would be part of a family factual matrix of the TTA.
Which the judge was heavily influenced by. I'm just trying to show you why he was influenced by it. In response to a submission by my learned friend that this paragraph we've been looking at the judgment is speculation, well, it surely isn't. If you have 40 million euros going out the door, it's not quite what's another $20 million, but we're in that sort of territory where these large sums of money are not, it's not impossible to imagine that this sort of money might have been found had it been needed. And that gives you an idea about how gaps in this contract might have been anticipated or apprehended at the time it was concluded. I put it no higher than that.
I mean, equally, the fact that there is potentially, by most people's standards, gigantic sums of money available in certain family circumstances is not, I think, is it a reason why we should not try to reach a commercially sensible interpretation, so far as we can, of the TTA. I mean, on the face of it, it looks like a document setting out legal obligations, which aren't all easy to understand. But at any rate, one should start from the position it was intended to make commercial sense. And indeed, the whole fact it was a bailout perhaps rather suggests that if anyone was going to end up in the stronger position under the contract, one might expect it to be Angeliki rather than your client.
In my submission, the starting point, given the family context, is probably not that actually the consequences of this agreement would be understandable and appreciable to someone acting as a rational commercial actor, because nothing about this agreement is commercial. It was a bad deal from the start. It was only entered into, the bailout was only entered into to save the family name and save Captain Frangos from the ship finance market.
But hang on. Sorry.
After you.
No, go on.
No, but I mean, yes, isn't that rather the point? I mean, it was a commercial problem for the family as a whole. It wasn't just something. I mean, John had dug himself into a deep hole on any view. But the ramifications of that, if a rescue deal wasn't successfully put together, could have wide ripples. We don't need to go into that, but I imagine that this hugely successful global Frangos, looking at the term broadly, Frangos shipping empire, must have a great deal of goodwill which needs to be preserved, and on the face of it, one of its ships being arrested in Singapore is not good news.
Yes, so the judge drew from all of this the idea that if there were gaps in the contract that otherwise looked unfair to the eyes of a commercial reader, that you might otherwise assume wouldn't be there because no commercial person would agree to a contract that had these gaps. The point is, probably the understanding was that something would have happened within the family to cure those gaps. So you can't test the construction of this agreement by reference to ideas about commercial common sense or good sense as a way to undermine what might be an imprudent bargain concluded by Miss Frangou that doesn't fully protect her in the circumstances that have eventuated in this case, which is what we say my learned friend's case is all about, especially their submissions about, in paragraph 38 of their first skeleton, which all go to hair trigger events and capriciousness or harsh effects. Those are all questions that you're coming at from the perspective of a rational commercial observer of this agreement, and those are not considerations that have as strong a role to play in this case. I'm not saying they're completely irrelevant, but they are undermined and muted because it is a perfectly acceptable answer to this contract that it does have some unpalatable consequences for Ms. Frangou. There are gaps in it, but that's just where the liability falls in this, because that's what she agreed, for whatever reason.
So we shouldn't be testing the rival constructions by reference to commerciality.
Not to the degree you might otherwise do in a completely generic commercial contract between arm's length, rationally acting actors. This, as the judge, in the early parts of my skeleton, I set out all the parts of the judge's judgment that deal with this. But this was an agreement almost reached through the coercion of the father, and that means you have to be careful before you assume that if Miss Frangou had been entering into a deal like this freely, or another deal in connection with another vessel, she would have agreed anything like what we see in this contract to protect herself from possible outcomes. That
I'm struggling with the rather one-sided nature of these submissions. The evidence, such as it is, suggests that father stepped in to help John on many occasions. If you say that one of the things that we should not allow to exist because it's commercially nonsensical is for John to be under an extended period during which his indemnity is still operative. But surely your argument runs in the opposite direction. If that's the consequence for him of being favoured with the bailout in the first place, why shouldn't we just assume that father might have stepped in to help John out? Why are you saying we should assume that the whole should be, that Angeliki should be left holding the baby and father might step in to help her, when in fact you could run the argument the other way and say, actually it would go the other way around. To the extent that father has stepped in the past, it's always been in John's favour, and if it means that his indemnity is longer, well, so on that basis, where do these type of submissions take us at all?
I agree with what you're saying, my lord, and the judge was grappling with that very question in the judgment at paragraph 73, which starts with the words, insofar as considerations of relative or disproportionate unfairness matter. So he was aware that you're effectively, in this case, choosing between two unfair scenarios. One where my client is, you decide, exposed to an indefinite indemnity, and one where, from Ms. Frangou's perspective, she's not fully protected for the consequences of the bailout that was imposed on her. And in the overall task of interpreting the contract, the judge decided, having weighed all the evidence, drawn inferences from it, seen everything happen, and looked at the terms of the contract, that it was more that the meaning of the contract was that the risk for the situation we're in now fell on Miss Frangou, not on Captain Frangos. So he decided the point you're grappling with in favour of my client. I accept that there are points going both ways in relation to the commercial attractiveness of the parties' constructions. I never said that those considerations are completely irrelevant. What I said is that they're muted when you approach this contract compared to how you might approach another contract. And the judge felt and decided, and we support that view, at paragraph 73, that overall, when you stack up the indicia on both sides of the commercial unfairness, exercise, when you view that against the background of the family background, the genesis of the bailout, the genesis of the contract, and the terms of the contract, you come down on the side of Captain Frangos' construction. But I'm not saying, I can't stand here, my lord, and say that my position on the extent of the indemnity doesn't involve an element of looking to commercial reality. But when you put it all together, which is what you've got to do, my lords, we say you come out in favour of my client's position. This goes a bit to some of my submissions in writing about the exercise you're undertaking, and the G&G case, which has been said against me isn't particularly relevant, the discretion case. But one of the points in that case was when the first instance judge is grappling with two imperfect solutions, and he or she weighs a number of factors to reach a view that one of those imperfect solutions is the solution, you have to have a little bit of deference to that process that went on. And just because you consider a different imperfect solution might be equally viable, and the judge could have decided that, doesn't mean that you should overturn it in light of all the factors that the judge had before him that you don't have before you today.
I'm still a bit troubled by that submission. I mean, obviously, we all know that's how one should approach an appeal on an exercise of discretion. I mean, we're talking about exercises of construction of a document, which can only in law have one meaning, and we have to decide what's right and what's wrong. And it's also the case, or frequently observed, that different judges will take different views on questions of construction, which is an unfortunate fact of life.
Yes.
But that doesn't turn it into a question of discretion. It just means it's part of the lottery of litigation.
Well, I'm not saying it is I'm saying it's akin to a discretion. The process that the judge goes through to resolve a construction issue like this, where he or she has to take note of inferences drawn from primary facts, which are feeding into the interpretive process, is different to a construction process where it's just a black and white question. There's no evidence involved. There's no inferences involved, and it's just a yes or no question. Here, as you saw in the excerpt from Lord Justice Briggs in Lewison yesterday, there is a spectrum, a range of possible decisions about the construction of the contract that could be reached. Once that decision's reached, it's locked. That is the meaning of the contract. I agree with that. But I'm not addressing that point. I'm addressing the process that the trial judge goes through to reach his or her view on the construction. And that is a spectrum. You can have different cases. This one is one where you can see from the judgment, the judge was drawing inferences from the factual background and the family background and feeding those analyses into his understanding of the contract, testing his understanding of the contract by reference to that background. And that is why you get into a pseudo-discretionary territory where just because you can see that a different construction might have been viable, might have been open to the judge, he didn't take it, he preferred an alternative. And all I'm saying is you should appreciate that when you're deciding whether or not...
Maybe this is really a quibble. I'm still worried about the use of the word discretion in this context. Perhaps one could rationalize it by saying it's really an example of the iterative approach described in all the recent authorities about testing a construction against its consequences and the surrounding circumstances and all the rest of it.
Yes, perhaps I could just show you the Associazione case from yesterday, because my learned friend took you to what I would say is the wrong bit of that, just as a segue whilst we're dealing with this. It's in the authorities bundle at tab 7. And my learned friend took you to paragraph 10 and said, well, that's the answer to this, to Mr. Kaplan's point. This is Lord Justice Clark saying we're talking about the judge's conclusions of fact, and that's not a discretion, so that's over. You remember that?
Yeah.
But actually, the relevant paragraph is over the page on paragraph 16, where Lord Justice Clark continues and says some conclusions of fact are not... Paragraph 16. And Lord Justice Clark says some conclusions of fact are not conclusions of primary fact of the kind to which I've just referred, which he's been talking about. They involve the assessment of a number of different factors which have to be weighed against each other. This is sometimes called an evaluation of the facts and is often a matter of degree upon which different judges can legitimately differ. Such cases may be closely analogous to the exercise of a discretion, and in my opinion, appellate courts should approach them in a similar way. Now, that's talking about evaluation of facts.
Yes, multifactorial evaluation. I mean, obviously, is frequently something we have to...
And I say the judge was doing that, if you look at the judgment, fairly, and then feeding that into his analysis of the contract, and tying that with the idea that different people can reach different views about the same words in the contract.
This sounds heretical to me.
I was going to say, I mean, surely there is... The judge obviously has a task to do, which is to find facts. And to some extent, a trial judge is given latitude by an appellate court if they've heard evidence. Sometimes facts don't require evidence. Once you've discovered what the factual matrix is, and there's no appeal on fact in this case, once you've got a factual matrix, the question is which bits of it are relevant to the interpretation of the contract, which is a question of law, i.e. you mustn't take account of matters which as a matter of English law are irrelevant to interpretation. The interpretation is to arrive at the true meaning of the contract, and there is but one meaning. that's it. Well, I mean, in the process of that, you might test your meaning against the objective standard of the hypothetical reasonable observer that is spoken about in the authorities on interpretation. But that's not an exercise which is fact specific or involves any exercise of discretion at all. It's just a legal process. So I'm struggling to understand where in all this there is any element of discretion or evaluation other than right at the start in terms of the matrix. And in this particular case, the one thing the judge did was to say that the matrix is very limited, and he set it out in paragraph 18.
Well, I don't think I disagree with anything you've said, my lord, but where I depart from you is that in my submission the judge began to draw inferences from the factual matrix, the primary facts that he'd found, when he was forming his view about the construction of the contract and testing it. And you can see that process going on in the passages of the judgment I've been taking you to. So his views about the ultimate correct meaning of the contract were influenced by his evaluation of the matrix and the inferences he drew from that about how the family would have reacted in certain situations. And that is something that is very difficult for you to second guess, having not heard all of the evidence, which would have led the judge to conclude about which evaluations and which inferences he was willing to draw. That's as far as I take the point. I think that's the only... If you don't think the judge drew any inferences from the primary facts in reaching his decision on the construction of the contract, then my point doesn't go anywhere. If you think he decided the meaning of the contract in a vacuum, only looking at the factual matrix and going no further than it, then I accept what I'm saying to you doesn't carry my case forward. But I don't say that's what he did. If you look at what we're talking about in paragraph...
The danger of starting to ask questions like, well, what would the family have done or thought, is that you start deviating from the words that they used in the contract and start straying close to reformulating on the basis of some perceived reasonableness a different contract than the one that they actually entered into, which we're repeatedly told is definitely not what you should be doing. You know, at the end of the day, they have, you know, this is a contract that has been put into writing. And the task of the court is to interpret the words which the parties used as a manifestation of their contractual intent.
Agreed. The way the judge was using his inferences was to test what the parties to the agreement would have said at the time, or how they would have reacted to the situation that's eventuated, had the officious bystander been on their shoulder.
I'm not sure that, I mean, that may be part of the test for an implication of terms in the old-fashioned way, but I'm not sure it's actually the appropriate approach to interpretation of the contract. Because doesn't it effectively move away from the words that they've used to sort of postulating what they might have thought that they wanted to achieve?
If the words are unclear is when you would go down that path. I accept, my lord, if the words are clear, you can't use the background matrix to undermine them. Use the background matrix and inferences drawn from it to either test your construction or to facilitate it if the contract itself doesn't disclose the meaning that the parties intended sufficiently clearly. And I don't say that the judge was doing what I would suggest is orthodox in looking at the words of the contract, which is what he says in paragraph 74, you can't escape, 74 and 75 you can't escape from. And then he's tested his view about the meaning of clause 5 by reference to the melee of factual matrix and inferences drawn from it. And I suggest that's entirely orthodox.
Thank you. I think we all have well in mind the rules of construction of contracts, and we have your submissions, so I think we should pass on.
Just to deal with one point, it said against me that my learned that the judge's construction of the election point necessarily anticipates an interregnum period between when the Brandon loan finishes and a sale or refinance takes place, and that therefore there must be some acceptance in his construction that there would be a period where the Brandon loan would be in default. And therefore, if you accept that, then why do you need his construction at all? And just a quick point on that, they make this point at paragraph 37b, Roman 2 of their skeleton. My point and answer to that is that there's no indication in the judgment at all that he envisaged that that sort of interregnum default period would exist. And for the reasons I took you to earlier, the proper understanding would be that someone had stepped in to pay the balloon payment on the day the Brandon loan matured. We showed you how much money was flying around in the family. With then any monies obtained by the refinancing or the sale of the vessel to happen later used to backfill whoever had stuck their neck out and paid that balloon payment in the interim. So the judge's construction creates a bit of a cash flow problem for Ms. Frangou, but that's a sort of cash flow problem that these sorts of parties would be well able to deal with, and not something that counts against. His construction doesn't necessarily have baked into it the idea that there must be a default, which is what I say the parties would never have intended to be likely. Yes, my lords, my alternative approach to the election, if you don't uphold the judge's view about that, is what I advanced at trial, which is that, I don't want to get too far into this, but everything has to be done by the cut-off date, and the law would be able to imply into the agreement easily machinery to make the successive exercise of the Clause 1 and Clause 5 options workable. It would be something of the order of Captain Frangos disclosing his intention irrevocably about his election enough months in advance of the deadline that would leave Miss Frangou with a sufficient amount of time to get her ducks in a row with a sale and a refinancing. And that, the example I used to the judge below is that if you know your mortgage is coming up for renewal, you sort it out well in advance. You don't leave it to the date that the mortgage is going to expire. And the same concept would apply to a contract like this. If everyone knows that you've got a hard stop on a certain date, the parties talk to each other and you get it sorted. If they don't talk to each other, there might be a dispute, but we're not in that territory. But it's not beyond the wit of the law to sort out something, as I would say, relatively straightforward as that.
Okay, how many months?
Sorry,
how many months ahead?
Well, because this wasn't a dispute, you'd probably need expert evidence about how long.
How many months ahead?
I would say 3 to 6 months.
3 to
ahead of the
6.
deadline.
So 3, 4, 5, 6?
Well, I can't give you an exact answer.
But that's not a very promising basis for an implication of terms.
Well, it would be influenced by what market practice was.
No. Sorry, if you're going to suggest there's an implied term, it has to be both necessary and so obvious that it goes without saying.
Yes.
So I'm just asking you.
Well, it would be a reasonable time, not a specific figure, and what that reasonable time would be influenced by market practice, evidence of market practice. If this had been a dispute, I'm sure the parties would have had experts on each side saying how long does it take to arrange a refinance.
Right, sorry, so is the implied term for a specific number of months, or is it a reasonable period?
A reasonable period, sorry if I was unclear.
And a reasonable period to do what?
Captain Frangos has to elect to exercise his option or not a reasonable time ahead of the end of the Brandon loan, so that Miss Frangou has certainty about whether or not she has the right at the expiry of the Brandon loan to sell or refinance the vessel. So she gets effectively a notice period of Captain Frangos' intention about whether he is going to exercise his option or not, and it's irrevocable.
And the reasonable period is not pinned to how long it takes or might take a reasonable person in the position of John to get his ducks in a row to buy. The reasonable period, in fact, is pinned to giving Angeliki enough time to get her ducks in a row if she's to choose to sell. To sell or to refinance.
Yes. So he doesn't have to say that he's going to, because that's down to him. So what he has to do is this, right? I could say, please can you just dictate the implied term that you want me to add to the agreement, because that's the normal basis for doing it. And I'm afraid I lost you during the course of this mission, but it's what? If he's going not to exercise the option, he has to communicate that sufficiently far ahead of time, a reasonable period ahead of time, the reasonable period being measured by reference to the amount of time it will then take Angeliki to either sell or refinance,
I say
and complete on the 1st of September 2015.
Yes. He has to elect either way. He has to irrevocably decide a certain period ahead of when the deadline comes down whether he is going to buy the vessel back or not. And he can't change his mind after that. And from that point, Miss Frangou can go ahead and make her preparations as a diligent businesswoman, knowing that a hard stop's coming down, by which time she needs to have completed certain steps. My lords, I think I should probably move on to the durability construction, and then I'd also like to deal with quantum before lunch, which we're coming up against quite soon. Yes, so the durability construction. I deal with this at paragraphs 60 onwards of my skeleton. And the judge deals with this at paragraphs 76 to 78 of the judgment. And my lords, at the heart of this construction argument is the idea that the TTA has as its essential premise Miss Frangou's 100% beneficial ownership of the TT, but Captain Frangos' responsibility exists nevertheless for funding 100% of Brandon's losses, within the ambit of what Clause 5 provides for. That's the central premise of this argument. Captain Frangos stands behind Miss Frangou as 100% shareholder, backing the company effectively for the period in which the indemnity is to Capt. And it's common ground, as we discussed yesterday, that at the latest by September 2017, Brandon's beneficial ownership had been split 50-50 between Miss Frangou and Captain Frangos through the settling of a trust by MEH, Brandon's direct owner, which is also a company owned and controlled by Miss Frangou.
So by September 2017, Brandon's beneficial ownership of Brandon's shares, is more accurate, was split 50-50.
Yes.
Do we actually know why that was?
We'll come on to that in some detail in the implied rescission argument this afternoon, which has as its central premise the MEH letter, the settling of the trust that we're talking about. And the reason why things ended up that way, and also ended up that way in relation to 5 other vessels that the siblings then co-owned, was the subject of intense debate at first instance, and was never resolved by the judge in his judgment. So I'm rather reluctant.
That's why I asked you the question, because
rather reluctant.
Search the judgment,
yes,
to understand why, and just can't find out.
In a nutshell, Captain Frangos' worldview is that was the equitable position to happen because he had an entitlement to own half of these vessels, which had all originally been his, and had worked their way into Miss Frangou's possession over the years as part of a global attempt to work with each other and develop a fleet together that they would run and manage for their mutual benefit. That's Captain Frangos' worldview. Miss Frangou's worldview is that Captain Frangos was suffering significant financial difficulties across his portfolio of vessels, and she had to step in to help him with each of those vessels and migrate them over from his ownership to her ownership legally. And she, out of the kindness of her heart or as a gratuity towards him, gave him back 50% beneficial ownership of each of those vessels, even though she thought he didn't deserve it, sort of thing, or had no...
I mean, in relation to this vessel, there's no doubt that it's the reason, as we understand it, is the latter, by her view, namely that she bailed him out. There's no doubt about that in relation to this case.
That doesn't explain why it's complicated, my lord. There was an acquisition of a vessel called the Orion 3, which we'll see in another guise later on, and Captain Frangos' position is that when that vessel was acquired by them jointly, things sort of changed with the TT, and it cross-collateralized with the Orion 3 and they started
Okay, well,
fresh. I'm not sure we need to get into it, and I think it would cause some stress for everybody if we had to argue that out before you without the witness evidence and the...
Can I also just say there is a trial about the MEH letter. It's called the Sangamo proceedings that was supposed to take place this week, which have been adjourned because my learned friends' clients amended their case. So there is a whole trial about it, and that's why the judge was very careful below not to say anything about the issues, because there is a separate trial on it.
What about the splitting of the beneficial ownership of...
Well, the effect of the MEH letter and what happens. And part of that will be why the MEH letter existed in the first place.
Okay.
I'm involved in those proceedings, Mr. Hill isn't, so I think I'll disagree with him slightly about what the content of those proceedings, but I don't think we need to get into it. Right. So I wouldn't accept that as being correct.
But can I just step back a few moments ago? I think there might have been a misunderstanding about beneficial ownership, the 50-50. So I'm not treading on any toes. In September 2017, Brandon continued, the shares in Brandon continued to be owned legally by the trustee,
Yes.
and that remained the same throughout. It's just that the beneficial interest under the trust changed.
It was created for the first... Well, again, that was a dispute. When
Okay.
it was first created...
Sorry, I was just trying to...
Quite right. I think everyone's happy to accept for the purpose of today that the split first occurred at the time the MEH letter was settled. There was a dispute at trial about whether it happened in 2013 or 2017. The judge decided he didn't need to resolve it, and we can operate today on the basis that it happened for the first time in 2017.
But it's the beneficial interests under the trust rather than the change in any way in relation to the holding of the shares.
Correct.
That's just
Correct.
what I'm
And
trying
that's
to get to.
true. That was never
Yep.
that was never in dispute at all. And so the essential part of this case is that once the beneficial ownership of Brandon had been split ultimately between Miss Frangou and Captain Frangos, the essential predicate of Clause 5, and Captain Frangos' promise to pay Miss Frangou directly for 100% of Brandon's losses fell away, such that the Clause 5 rights are no longer exercisable. And before I get into the detail of what the judge decided, I'll just pose a hypothetical which I outlined at paragraph 61 of my skeleton, which is, suppose instead of splitting the beneficial ownership 50-50 between the siblings, Miss Frangou had sold 50% of her interest in Brandon, ultimate interest in Brandon, to a third party. Can it really be said in that circumstance that it would have been the party's intentions that under Clause 5, Miss Frangou would still be entitled to be indemnified by Captain Frangos for 100% of Brandon's losses, running from September 2011 until July 2020? My lords, the answer to that question, had it been posed to the parties, we say would obviously have been no. Why would the parties have intended that Miss Frangou still be paid direct for losses by Captain Frangos, but now somebody else, a third party, was notionally responsible for ultimately funding as her 50% co?
Well, no, I mean, sorry, that doesn't follow at all. She owns beneficially the shares in Brandon. Brandon makes a loss of 100,000, let's say, over the period. If she comes to sell Brandon, the price would presumably reflect the fact that the company is burdened with losses of 100,000. Now, the owner of the shares may or may not decide to make the company whole. They certainly aren't liable for those losses. That's the nature of limited liability. But she effectively may have she will be on the guarantee to the bank for Brandon's inability to repay the debt to the bank.
And once she pays out under that guarantee, she...
That would be a product, amongst other things, the fact that Brandon's been making losses.
Yes. I think once she pays out under the guarantee, she becomes a creditor of Brandon because if she discharges, when you, as a guarantor, discharge a primary obligation,
Yeah.
primary debt.
We discussed this yesterday.
So even though she's paid out to HSH under the guarantee, she takes no real benefit. She's still on the hook as the ultimate beneficial owner of Brandon, because if Brandon has a debt to her or to anybody, and the only way it can fund, if it's a loss-making company, the only way it can fund that debt is to have monies put into the company by the shareholders. She is ultimately responsible for funding the loss that Brandon suffers. This is what underpins, in my submission, the whole idea of the indemnity here, not the personal guarantee, which is the primary funding of a loss, or MEM, the manager, primarily funding the trading losses. It's about, once that's all taken account of, who ultimately has to fund the losses that Brandon suffers in relation to those creditors, either Ms. Frangou as a creditor or MEM as a creditor, once they've primarily discharged these debts. And the answer to that is that if Brandon owes, let's talk about the trading losses, if Brandon owes if Brandon owes MEM $1 million, because MEM's fronted trading losses for it, and Ms. Frangou is the owner of the company, wants Brandon to carry on as a going concern, that money's got to come from somewhere. And the expectation would be she, as the 100% beneficial owner, would have to put money into the company to stop it from going bust, to allow it to continue as a going concern. That's the normal position, I would suggest, that the agreement contemplates. And then you have Captain Frangos standing behind her with an extra layer saying, I will give you the money that you would notionally need to fund Brandon's losses so it can continue as a going concern if Brandon incurs exposures to either HSH or to MEM or to anybody. That's the predicate of this agreement. And that breaks down when you get the split in beneficial ownership, because the idea that Captain Frangos would stand behind both his half beneficial ownership and Miss Frangou's half beneficial ownership as a backer to provide funds to that layer of the company's funding isn't logical. He's then responsible for his 50% of the company. She is responsible for her 50%. And if the company needs funding, the expectation would be that they each put in their proportional share of the monies required to stop the company going bust.
Okay, the way to put against you is that you don't go to that level. You simply say, look, this company, Brandon, operates with two sets of liabilities. One to HSH, guaranteed by Angeliki. The other to MEM, which is her management company. And those are the only two buckets of liability. You get to clause 5, and Angeliki triggers it by selling or refinancing, and you look to see what the position of Brandon is at that stage. There may be a shortfall to the bank, in which case she's called on her guarantee, and the shortfall is identified as part of the indemnity. The other unpaid liability of Brandon will be to MEM, because that's the operating losses, because they're, as you put it, fronted by MEM. So at that stage, given that MEM is her company, she needs to be made whole, so the indemnity applies to that. Now, I think the argument is that's as far as this goes. It just doesn't say anything at all about the shareholding. It's simply covering the two mechanisms by which Angeliki, which is why the payment's made to her, may suffer loss crystallised at the point of sale. It's either because she's called on the guarantee or because her operating company has suffered loss. And my understanding is that it said the indemnity applies to see her whole in relation to those two sets of liabilities. It's dealing with her in her capacity as creditor, either subrogated because she's paid out under the guarantee or because she stands behind MEM, but that's it. You don't need to start thinking about beneficial ownership.
Well, we say you need to go, because of the context of the bailout, with the beneficial ownership of the company being vested in her, you need to go deeper, because the inquiry that my learned friends stop at is too superficial. Miss Frangou is a creditor of Brandon, but if she's the 100% beneficial owner of it as well, that's slightly circular in that she is ultimately, as the owner of the company, responsible for a debt owed to herself.
But she's just suffered a loss. I mean, in the sense that it is said she has just suffered a loss. She will end up as a creditor, either in her own right or through MEM.
Yes.
And of a company, Brandon, which can't pay.
Which she is which is the sole beneficial owner of. So if you own a company and ultimately it owes a debt to you and the company can't pay the debt, where does that eventually rest?
If you suffered a loss.
Unless you want the company to continue as a going concern, in which case you would effectively have to fund the company with the debt owed to yourself to keep the company going if you wanted it to continue to trade, which is obviously the premise of this agreement. And the extra layer implicit here is that Captain Frangos stands behind Miss Frangou in that scenario. And so, well, if that would be for you to owe a debt to yourself in order to keep the company as a going concern doesn't make sense. So I'm required to put those funds in for you, standing behind you, so that you can make sure the company can continue as a going concern and discharge the debt that is owed to you, and therefore making you whole.
Well, on one possibility, let's just take the sale, the company won't be continuing as a going concern because it has sold the vessel.
Well, not to her.
No, just the simplest scenario.
Yes.
Let's say, putting aside timing, your client says, not exercising the option can't meet the requirements. Fine. Angeliki says, great, okay. By chance, I've got a sale. We'll consummate it next week. She sells. Sorry, she causes Brandon to sell the vessel. So Brandon is just then a shell. It crystallises a loss to the bank, which she is on the hook for and has a right of subrogation back in. And Brandon is left owing money to MEM. It's got nothing more to do, and it's sold the vessel. So those are just two losses. Brandon has no more means to pay it, doesn't have anything left with which to pay it. So Angeliki has suffered a loss twice. Once on the shortfall, because she was called on the guarantee. Once because MEM, her company, has not been paid the operating costs it fronted. So that's it. It's just two losses.
That she, as the ultimate owner of the company, would in normal circumstances have to foot herself.
Well, no. Why do you need to go through that contortion? She's just the creditor of the company and has suffered a loss in that capacity.
Yes, so Captain Frangos's indemnity is effectively providing Brandon with the funds to repay the debt owed to Miss Frangou, except it's being paid directly to her rather than being funneled through the company.
Okay.
And the reason why he's doing that is because he is taking the role that otherwise the beneficial owner of the company would have to take to pay Miss Frangou back, if she was going to be paid back.
He's just indemnifying her for her loss as a creditor.
Well, yeah.
Okay, right, okay.
But he's doing that. He's doing that by discharging a debt Brandon owes, that Brandon owes to Miss Frangou.
Yes.
The normal circumstance when that would happen, if it was going to happen at all, is that the beneficial owner of the company would, if they wanted to put money into the company for whatever reason, be the person that would have to discharge that debt. So he is sort of taking over that role from her, which doesn't make, and that's the reason why she gets made whole for 100%. But in the change scenario where the beneficial ownership is 50-50 and Brandon owes Miss Frangou a debt, why is it right that Captain Frangos should be funding a debt Brandon owes to Miss Frangou to the tune of 100%? Because the proper way to view a split beneficial ownership scenario is that she has agreed to ultimately bear 50% of the debt Brandon owes to her in accordance with her ultimate interest in that company. because as an owner of the company, you take the benefits and the burdens eventually. You can't, no one can get at you through the company. But if you want the company to continue as a going concern...
But you don't. The hypothesis is, why would the company be continuing as a going concern? It's a single-purpose company which was formed to buy this vessel, and the vessel has just been sold.
Well, my submission is at the end of the day, if the company is left with a loss, the idea that underpins this agreement is that Ms. Frangou will be made whole for the loss that the company has suffered. But in circumstances where she is 50% beneficial owner of that company and Captain Frangos owns the other half of it, where is the logic behind her still being indemnified for 100% of the loss Brandon has suffered? The connection between Brandon's losses and Ms. Frangou being indemnified for them, we say rests on the ultimate assumption that she is the owner of the company, but Captain Frangos is standing behind her. If she has no one standing behind her, the buck stops with her for a loss the company suffers, even if it has been primarily funded by her or primarily funded by MEM.
And the effect is that instead, in the second passage of Clause 5, the indemnity is to irrevocably and unconditionally guarantee the payment, in effect, to Brandon of the shortfall and accumulated losses. Isn't that the
payment
effect of what you're saying?
The guarantee is to pay Angeliki Frangou for the shortfall and accumulated losses of Brandon.
Or okay, you would say you'd insert of Brandon, or alternatively, you could read that as on your hypothesis as to guarantee that payment to Brandon, in effect.
I have to be careful about what I can say here because there are arguments about guarantees and indemnities and contracts of surety at first instance.
Well, I'm just using that word because it's there. That's all.
Yes.
The indemnification, whatever it is, the payment. You're saying you'd pop in the words to Angeliki Frangou on behalf of Brandon, and I was just short-circuiting and saying instead of it saying Angeliki, it would say Brandon.
Well, the contract
That's
doesn't.
the effect.
The contract doesn't say the losses of Angeliki. It says the losses of Brandon. So that's the framing focus for the losses. And as the judge found in his judgment, and Ms. Frangou feels the losses of Brandon reflexively via MEM and via the effect of her personal guarantee and her ownership of Brandon. Because if you're the owner of a company, when push comes to shove, you do feel the losses if your company goes into an insolvency procedure, insolvent liquidation, or you have to put money in to keep it going as a concern. As a going concern, you feel those losses. And that's what this clause has baked into it.
But these are losses from the operation and management of the vessel, which is, as we know, certainly now, the parties would have understood, looking at recital K, would be losses which would have been fronted, to use your neat expression, by MEM. MEM that deals with as I understand it, with the operation and management of the vessel day to day, and so it's MEM that will suffer the loss.
In the first instance, MEM is a creditor of Brandon, an unpaid creditor.
Yeah.
And the expectation would be, MEM's coming calling for its money, and Brandon's not making any money, that unless you want to be wound up, the shareholders put some money in, or the beneficial owners put some money in, to prevent that from happening. And in the circumstances where the beneficial ownership's been split 50-50, the expectation would be that Ms. Frangou puts in half of that money required to fund the debt to MEM, and Captain Frangos puts in half the money to fund the debt to MEM. And that's why the idea that she should, in the circumstance of a debt to MEM, be paid for 100% of it breaks down. The starting point of this agreement that everyone was labouring under, which was true until 2017, was that Ms. Frangou was the 100% owner of Brandon, but yet not ultimately responsible for funding the debts that Brandon accrued but couldn't pay to relevant creditors. When the beneficial ownership splits, that logic finishes, and you have a co-beneficial ownership structure, almost like a joint venture in relation to the company, where you're both entitled to the benefits, dividends, and after a solvent dissolution of the company, any residual profits as a residual creditor. And also, if things aren't going well, you put money into the company to keep it going, whether MEM's the creditor or whether anybody else is the creditor, whether HSH is the creditor, it doesn't matter, whether Ms. Frangou is the creditor. If you lend money to your own company, but it's beneficially owned by two of you, it may be that both of the beneficial owners have an obligation to you for the money you put into the company, rather than it all being one of the beneficial owners' responsibilities to indemnify you for the money you've put into the company, by even if it's through MEM or one of your other companies. That's the way I would encourage you to look at this and to understand why. This may become a little clearer when we look at the implied precision arguments later this afternoon, because we explore some of these same concepts then. They're very similar.
So do you say that the same condition precedent would have underpinned the operation of clause 3?
Yes, because the payments are made to either to Brandon or Miss Frangou, and that again shows the understanding that a prerequisite to that pseudo indemnity existing must be a commonality of ownership. Or it must be Miss Frangou's ownership of Brandon, because otherwise, why would you pay Miss Frangou directly for accumulated losses of Brandon? It's because he's agreeing to stand behind her ultimate liability. Not liability is the wrong word, because you can't push through a company to make a shareholder liable for losses. But it's the idea, for example, with security for costs issues. If you want to say your company hasn't got any money to put up security for costs, the courts will expect you to show why you haven't put money into the company to enable it to do whatever it is you want it to do. It's a sort of similar concept here. If you want the company to keep on going, the expectation is, as the shareholder, you'd have to put some money in, or the beneficial owner, you'd put some money in. And that's pregnant in both clause 3 and clause 5.
So is this right? If at the time that the option becomes exercisable by your client under clause 1, Brandon had not been owned 100% by Angeliki, but had been owned less than 100% by her, are you saying that the obligations that the conditions that have to be fulfilled are different? Because there's nothing stopping her. So just while you're thinking about it, there's nothing stopping Angeliki in this agreement from disposing of any part of her beneficial interest in Brandon during this period. The express restriction is on the obvious restriction is on sale of the vessel. In other words, it's Brandon that has to retain the ownership of the vessel in order to be able for it to be resold to your client if your client had exercised his option. But if your client had exercised its option at a time when Angeliki had disposed of part of her ownership of Brandon, are you saying that we have to read the conditions precedent differently?
No, but I would suggest that the difference between this clause and clause 5 is that it gives Captain Frangos the option to pay Brandon or Miss Frangou. So if Miss Frangou was no longer the 100% owner of Brandon at the time this clause was engaged, I would rather think that Captain Frangos would pay Brandon the monies that would still be 100% liabilities of it, rather than paying Miss Frangou. But clause 5 only is a personal liability that Captain Frangos takes on only towards Miss Frangou. So it doesn't give him the choice to pay Brandon. So the issue wouldn't arise in that way, my lord. I think if Miss Frangou only owned 50% of the company, I don't think anyone would be paying her for 100% of the exposures listed in Clause 3A. You'd pay it all to the company that actually suffered those losses and needed to be made whole.
I'm concerned that we have a whole further topic to deal with before
Yes.
short adjournment.
Well, I think the only, subject to any questions you have for me, the only further point I'd want to make about this is just a response to a couple of points made by my learned friends. They pray in aid of a case called the Gilbert Ash, which was very familiar to you. It's very often cited. We say this is just an irrelevant case to this situation. They say that by reference to Gilbert Ash, you can't construe the change in beneficial ownership as giving rise to the loss of the indemnity, because to do so would deprive Ms. Frangou of rights, and there's no clear words in the contract to that effect. But that misunderstands what Gilbert Ash is all about and what we're talking about here. Gilbert Ash is about where a particular construction of a contract might appear to inadvertently deprive one of the participants to the contract of common law or equitable rights that they otherwise would be able to enjoy. And so the idea is, well, if the corollary of your construction of a contract is that these important common law and equitable rights are going to be removed from you, you better have some pretty clear words. But that's not what we're talking about here. We're talking about the primary meaning of the contract and what effect and what the meanings of these obligations and clauses in the contract are, not about subsequent effects on equitable or common law rights. This is all about the primary meaning of the contract and the way it was intended to operate. So the Gilbert Ash case just is a red herring in this context. Then there's a rhetorical question posed to me that I think we discussed yesterday with my Lord Snowden, with Mr. Hill, about, this is at paragraph 49 of their skeleton, about what happens if Miss Frangou divests herself of 1% of Brandon to a third party. Can it really be said in that circumstance the indemnity goes completely? My first point is that it's a very unlikely hypothetical to be something that might actually happen. And whilst I agree that one can test constructions by reference to hypotheticals, the value of the test is only as valuable as the likelihood of the hypothetical. If you have to create infected and wholly unrealistic hypotheticals to strain a construction, then that's quite telling about the situation you're in. But if I do have to engage with that 1% hypothetical, whether it was 0.5% or 0.05%, we would say that the absolutely essential premise of this agreement is that Ms. Frangou remains the 100% beneficial owner of Brandon. And if she divests herself of any of the beneficial ownership of the company, all bets are off in relation to the indemnity. And as Mr. Hill said on his feet yesterday, what she would have had to do is agree a variation or an amendment to this contract if she wanted to divest herself of any of her interest in Brandon, to modify Clause 5 to then be able to meet that new changed situation. And there's nothing like that in this case. We say it is such an essential predicate of how the indemnity works, even a modest divestment of her interest would have that effect, and that's something she would have had to be aware of and advised of before she divested herself of any part of the company. Subject to any questions you have, that's all I wanted to say about the durability construction. I have the quantum construction points, which I'll try to get through before 1 o'clock. These are discussed at paragraphs 80 onwards of my skeleton. And the judge dealt with them at paragraph 81 of the judgment. And we may just have a quick look at that so you can see how he decided this. And there were three quantum arguments run, points of construction. The judge decided the first one, or indicated he would have decided it in my favour, and that's that if he disagreed with me on the durability construction, i.e. that he felt the indemnity could survive in principle a divestment in beneficial ownership, he would have effectively implied, through implication or interpretation, agreed that the percentage indemnity that Ms. Frangou was entitled to would reflect the new situation of the beneficial ownership shares. He didn't decide it fully, but indicated he'd go that way. And then he was against me on the two other points, which were that profits from another vessel need to be taken into account when you're working out what Brandon's losses are for the purpose of the indemnity. And then my final point that whatever, even if Ms. Frangou can exercise her rights under Clause 5 beyond 1 September 2015, the quantum of the indemnity stops dead at the end of the Brandon loan, but she's not precluded from claiming in relation to that quantum just because she exercises her rights afterwards. So I can deal with some of these quite quickly. Firstly, dealing with the point about losses being capped at 50% to reflect the changed beneficial ownership structure. And this is what I deal with at paragraph 91 of my skeleton. It's essentially parasitic on the debate we were just having about the durability construction. And it only really applies if you're against me that the change in beneficial ownership immediately cuts off the indemnity. And I would say, well, rather than it persisting at 100%, the party's intentions would have been the indemnity continue to operate in a diminished amount, reflecting the changed beneficial ownership structure. We say that if you don't agree, the indemnity would fall away altogether. And you had been asking the parties what would have happened in the circumstance of a changed beneficial ownership. They may well have said, well, it would reflect the new circumstance. That's all I really need to say about that. It's quite a very small extension to the durability construction. The Orion 3 trading profits point is slightly more involved, and I deal with this at paragraph 84 of my skeleton. And this issue all arises from the joint acquisition by Ms. Frangou and Captain Frangos of another vessel called the Orion 3 in 2013. And if I can show you what the judge decided about this, because that's important, at paragraph 25 of the judgment and 29 of the judgment, if you would be able to read those paragraphs, 25 and 29. And the point we start from here is the judge has made a finding of fact about a parole agreement that Captain Frangos and Ms. Frangou entered into in 2012 to the effect that the Orion 2 would be acquired to service the financing of the TT, and the profits of the vessels, if any, would be used, amongst others, to service borrowing related to each other. So not just borrowing, but amongst other things. So the profits of the Orion 3 were to be used, if applicable, to offset any losses that the TT was making and provide additional income to Brandon to, amongst other things, service its debts under the HSH under the Brandon.
I mean, I'm struggling just to understand this. I mean, as a company lawyer, I mean, what is he actually saying, or what's being said? Is it just one company just gives away its money to benefit another?
Essentially, the companies are being run, the vessels are being run in parallel,
right,
with a view that almost like a joint venture, the profits, if one's making a loss and the other's making a profit, the profits can be swept over to the company that's not doing so well to bolster its finances.
Oh, okay, but I'm sorry, can we talk in legal terms, please, rather than swept over? Are you saying that if one company was making profits and the other was making losses, the monies would be lent to facilitate the cash flow of the other company? Or are you saying that the first company would just make a gift of its profits to the other company?
The agreement, as the judge found it to be between the principals, in my submission, is that it would be a gift, not a loan. That if one company is making a profit, those monies are paid over to the company that's not making a profit to assist the loss-making company in servicing its.
Well, you see, it doesn't say gift, does it? I mean, he just says use its operating profits to service the financing, but that's just neutral as to how it's done. I mean, I fully understand why in a corporate group, if you've got one company that is generating cash and another company which is making losses, you might, as a matter of internal organisation, use cash generated by one to service the debts of the other. But it wouldn't be by way of gift, it would be by way of intercompany loan. Because otherwise, I mean, it's just contrary to any sort of basic concept of company law. Companies just don't exist to give away money. They exist to pay dividends to their shareholders and maybe make the odd donation to charity if it serves, enhances the reputation or otherwise of a company. But you can't just give away money. I mean, so I don't. I mean, it's neutral as to what he's saying here.
We could also look at paragraph 81.2, where he continues where we were looking at before, where he was dismissing the argument, but he conceptualizes the collateral arrangement at the end of 81 Roman 2 between the ultimate principles as the mixed allocation of an accounting for trading income. So this is not a accept everything you're saying about the position under company law, which I'm quite sure Captain Frangos and Miss Frangou are not company lawyers. And so when they were concluding their agreement about this collateral agreement, about how the profits of the vessels would be used, and particularly the profits of the Orion 3 would be used, I'm sure they didn't have in mind any of the peculiarities we're talking about. The fundamental point is, for my case, they agreed that profits used from the Orion 3 would be used to pay down the TT's debts. Whether that causes the hackles on your back of your neck to rise as a company lawyer is a different question.
Well, even as sorry,
I was going to say, I'm not sure that the mechanism matters for the purposes of your submission, but I don't think we should assume that brother and sister cook up these ideas sitting alone in a room. We already know, and I'm not suggesting that we take into account anything. I'm just saying that we know that they have their own in-house legal teams, and these are people who will also obviously will have all sorts of other professional advice, and their accountants will be jumping up and down unless it were all properly recorded within the separate companies. So I don't see that we can gain anything by speculating about these being brother and sister who come to these extraordinary conclusions for themselves. And what does it? Let's go back to the ultimate issue that you're addressing and your submission. And I don't think that necessarily any of these things are relevant.
Kim Loader, I'm grateful. So, I mean, the premise of my case here is that there was an agreement between the principals that monies from the Orion 3 would be used to pay down the TT's losses. So the question becomes, why has that not been accounted for in Miss Frangou's claim for an indemnity in relation to Brandon or the TT's losses? And our position is that any profits from the Orion 3 that did exist at any point you're evaluating the quantum of the indemnity need to be taken account of in the overall question of what the amount of the indemnity should be.
So are you saying that is that whether or not Orion actually paid any money across? Are you just saying Orion makes profits? Are you saying that its profits ought to be notionally, for the purpose of calculating the indemnity, to be used to reduce the operating losses of Brandon?
Yes.
Even if they weren't,
Yes.
as a matter of fact?
Yes, because that's what the principals agreed. That one of the parties that is the beneficiary of the indemnity has agreed subsequent to agreeing the contract in which the indemnity is contained in a collateral agreement that I will agree to the profits of this vessel, the Orion 3, being used to pay down the TT's.
So where is the agreement to that effect?
Well, I hope that's what I was showing you before, in that the judge decided across paragraphs 25, 29, and 81 Roman 2 that the income streams of the vessels were to be mixed, such that the profits of one vessel could be used to pay down the debts of another. And in this, the way things worked out, the Orion 3 was profitable.
But is the only formulation of this agreement what is said in paragraph 25 of the judgment?
25, 29, 81, 2, because it was an oral agreement.
25, so 29.
There's no documentary.
He just talks about. Sorry, the point I was making in 25 and 29 is the judge's finding of what the agreement is could mean either use as a cash flow matter, but then be reflected in intercompany loans, which would be the conventional way of doing it. But it could mean gift. But the judge doesn't decide it. He uses language which is neutral on that point. He just talks about using operating profits to service the financing of TT, but he doesn't say how that would be dealt with as between the two companies.
He doesn't, my lord, but I would say it's implicit from the way he disposes of the argument that he didn't take the view that these would be loans, because he doesn't dismiss it on the basis that, well, the money, the potential entitlement from the Orion 3 would have to be paid back, therefore it wouldn't be capable of diminishing Brandon's exposures in the final accounting. He dismisses it on the basis instead that, on a point of construction, that he says the income stream from Orion 3 doesn't fall within the wording in the contract. So I would suggest to you that if he hadn't thought that the agreement the parties reached prima facie entitled Brandon to the benefit, the final benefit of the Orion 3's income, he would have said so. I accept I'm having to piece it together from a part of the judgment where he'd already decided things in a different way, so things are slightly clipped compared to earlier on in the judgment, but that's all I've got to work with.
Right. So you say what there's a variation or collateral contract to this agreement we're looking at?
Yes, that's what the judge found, a collateral agreement between the principals who are the same parties to the TTA. And there is an agreement that these monies be used to pay down TT's debts, TT's exposures, and so giving effect, as a matter of the proper interpretation of the TTA, when you're trying to work out what the losses of Brandon are, the shortfall on accumulated losses of Brandon are as a matter of construction of the TTA, the question is, should you be looking at those figures in a sort of gross loss way without taking into account any benefits that Brandon was entitled to at the time the indemnity is crystallized? Should you only be looking at a combination of its trading income from being chartered out against its expenditure plus the exposures under the financing with HSH, or should you also be taking into account a contingent income stream that was agreed would be available to it after this agreement came into account? And you'd be sitting on the shoulders of the parties at the time the agreement was made and say, if Brandon comes to the benefit of an extra income stream after the date we've concluded this agreement, should that be taken into account when you're working out what the accumulated losses and shortfall from the operation of the vessel are? And I would suggest to you they would say obviously yes, because the purpose of the indemnity is not to give Miss Frangou a windfall, it's to make her whole. She's not meant to end up from the indemnity, and she's not meant to end up down from it. It's meant to complete her. And so if you're not taking into account an extra revenue stream that Brandon had a right to, you are in fact overcompensating Miss Frangou for the accumulated losses from the operation of the vessel. And if there's a point taken against me about whether losses derived from the collateral contracts, the cross-collateralization of the TT with the Orion 3 are from the operation of the vessel, I would say once you've cross-collateralized the vessels and they're being sort of treated as a mini fleet amongst themselves, that is an income stream derived from the way the vessels are being operated from that time. And so it falls within the language and the spirit of the indemnity. And the fact that the claim doesn't take into account what are not immodest sums. In 2020, the figure, the Orion 3's profits is 1.5 million. It's not an inconsequential amount.
That's
If you're-
2020.
in 2020, the reference to that in my skeleton is that paragraph 29, paragraph 84, footnote 57. I don't think it's a disputed figure. It comes from my opponent's pleadings.
Yes.
And the figure in 2015 is set out at paragraph 90 of my skeleton. That's about $900,000. See, these are not Mickey Mouse figures that we're talking about here, which haven't been taken into account.
But I want to just try and understand something. If this agreement was reached, as you say, in the last quarter of 2012, are you saying that the monies were actually paid across from the operations of Orion to Brandon, or weren't?
My understanding is they weren't.
They were not.
They were not. They're not reflected in the account.
So they're not reflected in the accounts. So did at some point one person say to the other, hang on, why aren't you using, why isn't Trinity Maritime giving its profits, donating its profits to Brandon?
I don't know the answer to that question. It wasn't something traversed at first instance. I can check over lunch with Captain Frangos and.
Your case is that although it didn't in fact happen, all of the profits made by Orion 3 Trinity Maritime ought to be deducted from the losses from the operation and management of TT by Brandon.
Yes,
Basically.
yes, because that was what everyone agreed would happen. The money's you can get at it both ways because there's some fluidity between.
And the judge said no.
The judge said no.
On a construction.
On the construction of the breadth of the indemnity, not on the premise that the agreement the parties had reached didn't go that far. He just said, well, income stream derived from a collateral contract doesn't fall within the words of the clause. And in my submission, that misunderstands the premise of the indemnity and the breadth of the wording in the clause applied to the situation that existed.
Right, but the extent of the basis for your claim is an agreement as recited by the judge in 25 and 29. Is that it?
Well, it was the subject of great dispute.
Yes,
but this is what the judge reduced into the judgment. Yes, and I can't go. Part of my.
So you live or die by the.
Yes,
put it
that's the approach
dramatically.
we've taken.
You live or die by the wording of the agreement as formulated by the judge in paragraph 25.
Yes, because on appeal model, I can't ask you to go back to the witness statements and re-resolve what the judge resolved after hearing cross-examination about the existence of an oral agreement. It would be, I think, totally
what he also describes it as, you refer to profits. In 29, he refers to income, and in 81(2), he also refers to a collateral arrangement between ultimate principals as to mixed allocation of and accounting for trading income. So that is quite a wide concept.
Yes, it is. But I am working with the tools that the judge has given me.
Absolutely.
And,
that's all we have.
So, my lords, that's all I think I wanted to say about that issue. We're not seeking to go behind the accounts, go behind this miraculous evidence. That evidence is only as good as what is taken into account in calculating all the figures. The accounts are only as good as the auditors have been told Brandon was entitled to. So it's not saying they're wrong. The auditors have made a mistake. It's just about giving effect to an agreement. And then I might be able to do this in a couple of minutes just before we finish. The final quantum construction argument is about losses being capped at 2015, no matter what, and no matter whether Ms. Frangou was entitled to exercise her rights afterwards. And the predicate of this construction is that you're with me on everything I said about the duration construction, about the importance of the 4-year tenor, and the anchoring of the Clause 5 indemnity to the period at the end of the Brandon loan, but you disagree with me and the judge that the rights had to be exercised by the 1st of September 2015, in order for Miss Frangou to crystallise her right to that indemnity. So she could exercise her right to crystallise the indemnity at any point through a sale or refinancing after 1 September 2015, but she's always pulled back in terms of the quantum of that indemnity to the 1st of September 2015, because the proper way to interpret Clause 5 is that Captain Frangos hadn't agreed to underwrite the economic fortunes of the TT beyond the financial position at the end of the Brandon loan, whatever that may be. And so this would feed into my arguments earlier about the references to the new loan in Part 1 of the clause, anchoring it to concepts of exposure at the time that the Brandon loan expired but not beyond, but I'm in a sense of this is a mitigation from the otherwise harsh result that if she doesn't choose to exercise her right by 1 September 2015, she's shut out of the indemnity she's accumulated a right to up until that point. We say that that is a possible alternative construction from a duration perspective. And as a consequence of that way of looking at things, crystallising the indemnity on the 1st of September 2015, we say the trading losses are capped at that date. It's about $4 to $5 million. But there's no shortfall component to the claim because there was no crystallised shortfall under the Brandon loan at that date, because in fact it continued and was extended and the crystallisation didn't take place until 2020. And we say, therefore, if you're stuck at the snapshot at the end of the Brandon loan, you can't factor in a shortfall component to the quantum of Miss Frangou's indemnity. That is taken away because she chose not to sell or refinance at the point she could have done, and the fortunes of the loan and the value of the vessel were from that point up to her to bear and can't be latterly retro-engineered into the indemnity back at 1 September 2015. My lords, unless I can help you further, that's probably a good place to break, and then I'll turn to implied rescission after the short adjournment.
Thank you very much indeed. 2 o'clock then.